This one's Trump. Last one you gave me, they're not in.
Yes, it is. So.
Haverhill on Clark versus Leaper.
Good morning, Your Honor. Ronnie Hajjad for the plaintiff.
All right.
We don't have this text.
Leaper. They are not here. Would you like to take a default? Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Yes, Judge. There is currently a rent to retain. Sorry, Your Honor. Plaintiff moves for default judgment for possession. Rent to retain is $6,306.14. Attorney fees and costs in the amount of $170 for a total redemption amount of $6,470.14. We are seeking a writ date of July 10th, 2026. No money judgment is entered, and to my knowledge, the defendant is not a minor, incapacitated, or in the military, and the property has been kept fit for intended use and purpose during the duration of the tenancy.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue and intended use. Then I'll sign that when we have it.
I just want to make a correction.
Okay.
Use rich.
All right. Do you have a particular? Well, we may have the same issue in these cases. So just call the other two. Haverhill on Clark versus Shanley Smith, and Haverhill on Clark versus Kanika Woods.
Good morning, Ronnie Hajjad for the plaintiff.
Morning, Your Honor. Master Chair, I think requesting permission of this pursuant to Rule 81120, restraining court rules. I'm under the supervision of Attorney again, and I'm Mr. Watson Smith.
Permission to practice. Good morning. Permission to practice is granted. All right, where are we on these cases? We may have a procedural issue. We think Ms. Haddad, you attempted to file a response
Yesterday, however, we weren't aware that there was a age limit.
Okay, just so that we're aware, I was not aware of that either. I'm going to be checking into that because as I'm informed, somebody said it was 15 pages.
Correct.
Well, if they're going to do that, I'll just be blunt about it. They should do something consistent with the court rules, which would limit a brief maybe to 20. So I don't know how I tell. This is what happens when lawyers don't make decisions. Go ahead. I'm sorry.
All right, we can proceed. We can argue our sister counsel can argue her motion, and I can respond orally. I mean, I am prepared to proceed on these two cases with our response.
Okay, I guess. Yeah. I mean, I'd certainly like to read through your response. I only got them this morning, so I haven't had an opportunity to do so, but I guess I'll allow argument to continue. I may not give a decision on it.
Okay.
I think, from my understanding from the last hearing, new notices were going out in any event.
Actually, we held off on sending out the new notices, Your Honor, because our position is clear on the CARES Act issue. So.
Fine.
Your Honor, we would like to request additional time so we can compose a written response, written reply.
A reply to what?
To the response. Yeah, we received the kind of,
Can I just say as a practical matter, had they on June 12th sent out new notices, which I think they would be entitled to do, we're going to be right back in court, even if I grant your motion. So I don't mind giving time for you to respond, but
You know, Your Honor, here's the thing. I mean, at the last hearing, the defense counsel presented us with a motion to dismiss.
I know.
Which purports to be a motion for summary disposition. I think that we can proceed with arguments today if they're not ready to argue their motion, at least. And I can argue my response to their motion. I just don't think that any further delays on this. I mean, if we're talking procedurally, 21 days was the time that I should have been given before, before the previous hearing for a motion for summary disposition. But I received it the same day, and we responded to it within 2 weeks. We have, authority that supports our position.
Your Honor, if I may, the motion was filed not to be heard the day after. It was filed for the court to give us a hearing date, but it was appropriate for the court. And the courtrooms do require a response to be filed 5 days by mail and 3 days by electric or personal service, electronic personal service. We're just asking for an opportunity to file a written reply.
So sorry, just for correction, I think Sister Counsel's confused. It's supposed to be 21 days and then giving me 7 days to respond. So it technically should have been filed 20 days before the previous hearing.
okay. And I'm just talking from a practical standpoint. If I grant the motion and you filed a new notice, then there's just going to be a new case. It's going to at some point moot itself. These cases will move themselves and they will just start again.
Right, but here's my issue.
Okay.
If you grant their motion, then you're setting a precedent here, and I'm prepared to argue the basis of their motion, because otherwise, I mean, we have federal authority here that trumps their authority, their persuasive authority at best. And so I would like to have an opportunity to argue my motion, the motion, because of the fact that if you dismiss it, then we have to instruct our client to start filing 30-day notices, and that's not necessarily the case anymore. It's our position. And so you're setting a precedent here, and then
Counsel, I have issued a written opinion
yes.
previously on this. My colleague, Judge Washington, also issued an opinion. Hers was appealed. There was then a circuit court order, which I believe the defendants may be relying upon. However, I think that circuit court order, with all due respect to the circuit court judge, is in error. And by the way, since it did not involve my case and did not involve a specific instruction to this court, I don't believe that I am bound by that. And I think that is very, very clear. But I've heard all of these arguments before. So unless there's something new.
Well, so the Department of Housing and Urban Development issued a revocation of the 30-day notice, Your Honor, and that was effective as of March 30th, 2026. That's
new.
Correct. And that is the authority that we are basing our response, and that changes everything.
That was in your
correct.
Said I haven't had an opportunity.
Correct.
And that's
Thank
what
you.
we're asking to reply to, Your Honor. And if you want us to proceed, you can proceed, but I think it would be.
Did you attach a copy of the revocation?
I did, Your Honor. There's one exhibit 1, and the end, and that is the federal February 26, 2026, and it was issued by HUD, the federal organization that was also behind the 30-day.
Well, Yeah, the original 30-day actually came out of a federal act, which was a result of COVID.
Correct.
And you've not seen this?
Your Honor, we have seen it and it's actually, I think, I'll let Mr. Shea, or sorry, I'm jumping in when he's here to argue.
So Your Honor, the effective date of the interim final rule has been delayed indefinitely. According to the notice on March 13, 2026, the HUD has now treats us as a, sorry, I apologize. HUD put out a notice saying that this effective implementation date has now been delayed and is now treating it as a proposed rule, awaiting comment and a final rule. On another point,
So is that just, then that would not be authority for this court you're indicating?
that is correct. It's not yet in effect.
Are you aware of the, Ms. Haddad?
The delay,
Yes.
so again, defendants are relying on persuasive authority. This is a federal regulation that has the effective date was originally March 30, 2026. And what they're stating is that it has been delayed as of, I'm sorry, what was that? March 13th?
March 13, 2025.
Okay, it does not negate the weight can still be put on this, the federal regulation, Your Honor. I don't believe that it's I believe that it's still persuasive authority at best here, or in the least, Your Honor. So I believe that we can still rely on this, on the HUD repeal.
Your Honor, my approach.
What is it? What are you trying to give me?
The notice that the HUD put out on March 13th.
So I would need to see that first before you show it to the judge. And then,
Oh, sorry.
yeah, so,
Wrong.
no, that's it.
You have the same things.
Yeah,
Okay, thank you.
I believe so.
That.
So this is pending consideration of public comments, Your Honor. And I know that this is a process.
So is the rule in effect pending public comment, or is it not in effect?
It is not in effect pending public comment.
What?
It is not in effect
Does
pending.
it say that?
It says,
It says it's delayed. Pending consideration of public comments.
yes, Your Honor, it says the effective date is delayed indefinitely pending public comment.
And it's just basically revoking any 30-day requirement of the CARES Act, which I don't think applies in any event, but
Your Honor,
go ahead.
since this is the notice here in question that we're discussing revokes existing HUD rule about a 30-day notice requirement. The notice requirement,
Existing notice.
yes, HUD promulgated their own rule requiring 30-day notice for specific properties.
No, they didn't. That's not how that comes about at all.
I don't think he's referring to the CARES Act. He's referring to the rule that this rule is trying to revoke.
About the 30 days.
This, because I think it would be a lot more clear if.
No, I don't think it gets any clearer. I mean, in my mind, it doesn't need to really be clear because I don't think it applies in any event. But I'm just trying to get your argument.
Yes, so Your Honor, the CARES Act notice requirement that we are attempting to argue here is completely separate from the rule that this HUD notice is attempting to revoke. The rule that HUD is attempting to revoke here is HUD's own enhanced 30-day notice rule. it has additional requirements, like informational requirements for public housing
But
authority.
wasn't that based upon the CARES Act?
Yes, it was, Your Honor, actually. It's the revocation applies to the also to the requirements for termination notices. So he's essentially, it's the same thing. It applies.
I mean, part of that rule was a result of individuals' interpretations of the CARES Act, whether or not it still continues, right?
And here's what's concerning to me. I mean,
Isn't that correct, what I just said?
I don't believe so, Your Honor. I believe CARES Act is a federal statute that, HUD obviously has no authority to revoke or rescind a federal statute. That's how the 30-day notice requirement.
yeah, I disagree with that. It is a federal agency and it has this is effective law.
Well, I mean, I think that's a very dangerous argument to make because part of my concern with applying part of the CARES Act is that I think the CARES Act, when I look at it, really truly falls on its own accord because there are certain provisions that are specifically COVID related. And there is one part that everybody is hanging on to that I just think falls with the entirety of the statute. So your argument that you're making now actually fits quite well in what I'm saying, quite frankly. But
Yes, Your Honor, there is indeed a sunset date for other provisions of the CARE Act, such as the eviction moratorium, such that sunset.
oh, I know the whole argument. I heard it over and over. But
I mean, Your Honor, this is what's concerning to me is that defendants have opted to use the court's resources to file on behalf of the defendant they've been given ample notice now. They have legal counsel has filed a motion on their behalf. And so I don't think that this is beneficial to the defendant at all. I think it's disheartening to me that this is how they decided to
how much is each tenant's monthly rent?
for Haverhill.
Yes, how much?
For 1275 for Ms. Smith.
Ms. Smith is $12.75. Pardon? Ms. Woods' rent is $15.58.
It's 1568, but I can double check.
And the other one was what? Pardon?
1275. Oh, I did wish for it. I got a job. That's what I was saying. You wished me luck on my interview. That's the word.
Oh, well, I don't know if my luck had anything to do with it, but congratulations. What is at this point plaintiff's claim on as far as rent on Smith?
So for Ms. Smith, her balance that's due and owing is $5,450 in rent to retain, $170 in attorney fees and costs, for a total of $5,620 due and owing.
And that's going to go up tomorrow.
Gonna go up tomorrow.
And on the other case, how much is owed?
On the other case, it's a lower amount, Your Honor. It's $962 in rent to retain, $170 in attorney fees and costs for a total of $1,132. And so, unfortunately, this is the route that we've decided to take here.
Your Honor, Ms. Woods disputed the amount that she owes.
Pardon?
Ms. Woods disputed the amount that she owes with the plaintiff. She has evidence of receipts that she had provided with the.
I imagine we're here in court. There's always a dispute. I just asked what plaintiff's claim was. Going back to the regulation by HUD. How long was the comment period?
So it was, comments were supposed to be submitted by, I believe, April 27th or so. So it would seem that they were supposed to be submitted by April 27th, 2026.
Just says indefinitely on pending consideration.
No, they can't have a comment period indefinitely.
That's correct, Your Honor. The comment deadline is April 27th.
All right.
So it states that HUD is treating this interim final rule as a proposed rule due to the comments submitted. So again, I don't think that it's.
Well, I've got to review it myself. And so I understand that there might be some delay, but how much time are you looking to respond to this? Since it is just a piece of the actual thing.
Because Attorney Kim will be out of the office due to the upcoming holidays, we're hoping to request about 2 weeks' time.
All right. I'm going to permit a response to that portion. I won't hear argument today on everything. I'll hear it all at one time. I will. I'm going to do two things here. I'll give you to the 14th to respond. I don't want anything else after that. Anything else after that, I'll just hear an oral argument. So, and then what is my next? Because I'm going to need time to look at everything. But
July 1st.
no, I'm going to need more than a week.
4th
Or so.
11.
4th or 11th. All right. Then what I'll do is I'll adjourn this to August 4th, 2026 at 9 a.m. for a hearing on the motion. In the interim, I am going to order escrow in each of these cases. It's effective for tomorrow. So it'll be $12.75 for Miss Smith. That needs to be submitted within 7 days of today's date to the court. And then I have $12.75 on that one. And then did we ever determine, is it $15.68 on the other one, $15.58?
Is. And it's 1560 in some invoice.
All right. I'll order escrow in the amount of $15.68. Again, that must be filed with the court within 7 days of today's date or submitted to the court. I will indicate to the parties that if escrow is not paid timely, the court's intent will be to set an immediate trial pursuant to the court rule in both cases. Anything else on these?
Further remarks.
Oh, so look happy, right?
Mm-hmm.
Yes.
So, housed funding application. And if that
Funding from,
emergency housing fund, and there's what to do, if that should come through and a check is made to landlord instead of to the court, would that suffice?
If a check, if you provide to the court that there's payment and it's made to the plaintiff, I would direct plaintiff that they need to accept it. It would not be an issue. Is that going to cover the entire amount?
Oh.
If it's paid? I mean, if they approve it, then that would suffice for, well,
But-
that's for who? Miss Woods or Miss Smith?
She's starting a new job. I don't think she'll get a paycheck within 7 days. Just so the court is aware. It's a full-time job, but she will not get paycheck.
Well, what's cap on the emergency fund? Okay, but then the problem's going to be that I am going to be somewhere in the neighborhood of, let's say, it's 68. I'm going to be in the neighborhood of $6,900 on her case. So if 4 comes through, she's still going to have to keep up continuing rent. So, I mean, that assistance seems to me would be for back rent and not for future rent. So she would still have to, if she gets that funding, but she still has to pay the rent going into the future. It would seem to me.
Correct, Your Honor. So that would
I
be,
understand where the court is going is. When need to be pay down back. And then I do have one other concern, Your Honor, regarding the order for escrow and the court saying there's going to be immediate trial.
That's the rule. That's not just the court saying it. That's the rule.
Well, Your Honor, if the just hypothetically, the court lacks jurisdiction on the CARES Act issue, then how could a trial proceed?
Your Honor,
Before ruling on the motion?
respectfully, Your Honor,
I don't believe I lack jurisdiction. So
jurisdiction, I think that you're getting your issues mixed up respectfully. The court has exclusive jurisdiction over these matters.
it may be why, Ms. Kim, and maybe your office should think about this, why when I issued my opinion, it was not an issue of subject matter jurisdiction, because I don't think a federal rule divests this court of jurisdiction. And why I viewed it as an affirmative defense, which you could put forth for the court to rule on. I think that if people at your office had thought about it strategically, they probably would have agreed with me. But you chose not to. So now that's where you are.
I don't quite understand what you're saying, Your Honor.
I know that has been a problem. Anything else?
No, Your Honor.
All right.
Escrow order stands, correct?
The escrow order stands. Submit that to the court. So sign off on it, please.
For both. What was the amount for,
That's okay. It was 12. I ordered for Miss Smith the amount of $12.75, and Miss Woods I ordered $15.68. What? What's think?
Thanks.
Oh, he needs to actually talk to me. Okay. What? Just give me. Clark Road Family Housing versus Cindy Jim. And there's somebody else.
Do not see defense counsel here at the moment. Here, he is in the court. He is in the courthouse. You want to pass this? I'll go check him out for you.
Well, I don't have anything necessarily past two, but if you could go see if
Yes, sir.
oh, find him.
I mean, he's just in the breakout room there.
On. Okay. And there's nothing contested. I've called the case, counsel.
Never going to about for the defendant. You know, what's the sound? What's the sound?
It's P7. Thank you, Connor.
All right. I'm almost afraid to ask where we are on this, but I have three motions, I think, before the court.
Yes, in terms of my motion, I put forth a motion to withdraw as counsel to the breakdown of communications.
But you filed motions in limine also?
Yes,
And motions to compel discovery.
yes.
Okay, well, I'll hear those and then I'll hear your motion to withdraw.
Okay, and in regards to the motion, the motion to compel the discovery was.
Well, it's a motion to compel specifically depositions.
Yes. We put forth a motion to compel deposition as during our second court day, we respectfully requested the court consider depositions in regards to 3 people that we think are important in terms of the facts of this case. So things in the interest of justice, there's a numerous amount of allegations against my client. We think that these people have information that would be helpful in presenting a defense. There's a number of witnesses, a lot of allegations against my clients.
Why would I need a deposition of a police officer?
The police officer was involved in regards to the investigation of several complaints that have been alleged against my client.
So why would he need to be deposed, I guess?
That's what my client is requesting.
Okay. So there's not a basis other than a request and a wish or desire.
He wishes to speak himself, if you can be heard.
Go ahead.
Morning, Your Honor. Thank you. The reason I requested the position of Officer Lawrence is because, as we've alleged, this landlord has the management. The real reason for this lawsuit against us is retaliation, because I reported them to Bishop, and that they have weaponized Saline Police Department.
These people weaponize Ipsy PD? Okay, you can stop there because that request is denied.
So,
Without more, that is absolutely denied. If you're going to tell me some landlord decided to weaponize the police department,
well, not that
that's going to be a complaint you're going to have to address as police department. And I don't believe it. Why would the keeper of the records for the plaintiff need to be deposed?
Because that goes into the part of the matter as well. When they started a plan for motion to try to look at me making me look bad, which then essentially led to this lawsuit for eviction. They committed certain acts in the office and on the body cam too that I've actually reported all to, I should state, to strengthen my argument here.
What?
We filed.
Is there a specific person you're saying did all those things?
Pardon me?
Because I don't know who you're referring to as the keeper of the records.
I don't understand keeper of the record. What does that mean?
Looking at your motion to compel depositions. Paragraph 8D. Plaintiff's keeper of the records.
Yeah, I think what he's referring to in regards to that is he believes that there's information that will help exonerate him from the charges, such as video or cameras set up around the complex. And
have those been requested?
Discovery's been requested, yes.
And that was camera footage and the like?
All discovery was requested. Even electronic discovery. So the full range of discoveries was requested.
And has plaintiff not provided it? I guess I'm not clear if it's been requested. Where does a deposition help with that?
And I mean,
go ahead. I don't care either one of you because
okay. Yeah, sure.
I mean, anybody can dig a hole for themselves. So go ahead. You two bet it.
Well, there are certain acts behind the scene which I think they've committed to the management to essentially weaponize a few other tenants too. Your Honor, we've filed a complaint with Michigan Department of Civil Rights, and we even met with the state administrator a few weeks ago, Cindy and I, and they opened up an official investigation on April 29th against the landlord for 4 items: retaliation, disability, and discrimination on the basis of national origin, and sex. And that investigation is active. Plaintiff.
Okay. Assume everything you say is correct.
Yes, sir.
Why do I need a deposition?
Deposition is to essentially dig for more information.
That's not the way that works.
That they've done. That's my.
Who is Paul Spencer?
Paul Spencer is the CEO of K&G Prestige.
You can stop there. You can stop there. Why do you need his deposition?
Because Paul Spencer is the one who responded to an email that I sent to our Mitchell board and him. My email was dated March 2nd. And within a few days, he decided to, and he emailed them saying essentially he's going to evict us. And they'll retaliate and against Sydney both. So it's important that Mr. Spencer is deposed.
Why?
I thought it would be getting some more information my mind that we could expose more information for the clarity of the sport.
So it's a fishing expedition.
Fishing expedition. Well, to try to find out what happened behind the scene. Sure, under oath to be deposed.
Who is Sheena Mickens?
She is the on-site manager who will be here at the jury trial to testify.
Why do you need her deposition?
She's the one who also made all these false and allegations against me, which are listed in the with summons, many of which actually don't apply to me. I found that on Saturday, just this past Saturday, because there were complaints by tenants who don't even live in our building, and it wasn't even about me. And they used those as a basis to file this complaint with this court. Which in my view is, well, doesn't matter what my view is. So there's so much behind the scene that they've done. One of these complaints, actually, which I think may be valid, is a complaint by lieutenants who was essentially coached and helped and weaponized.
Everybody's being weaponized.
Well, not everybody, but a few, yes, who got all the facts. She made allegations that are untrue, baseless, and so the responsibility in a complex for a poor maintenance job that they've done. They blamed me.
Have interrogatories, and I think there were interrogatories, requests for production, and admissions.
Yes, Your Honor. We served the plaintiff that we received approximately 360 pages in terms of discovery. I served another request for admissions and interrogatories just last week. So, I mean, in terms of what.
And all of those have been answered.
Your Honor, if I may, we responded to the first set, gave it to him on Thursday afternoon. Friday, he drove another set to my office from, so we got that to work on still, Your Honor.
How many interrogatories are there?
That's the second one that I drove is all.
Well, listen to my question. How many interrogatories are there?
It did not count Steve over. Your Honor, we're just going to respond to them because we're not going to try and play those games.
No, I understand, but I also, in district court, you have to ask permission before you get any of that. I'm not saying that you didn't get the court's permission, that there could be limited discovery, but I also don't, I guess, allow discovery or use your client's phrase to be used as a weapon or weaponize it to try to bury somebody to do something. I mean, it seems to me that they've responded to the discovery request. I'm a bit concerned that then there becomes a second set of discovery. When this really is a landlord-tenant case. All right.
I would have to double check, but I think in terms of the number of interrogatories, I think it's under 30 questions. And then request for admissions, I think is probably like another.
So under 30 questions.
I think it's like 15 to 20 questions. I mean, sorry, 20 to 30 questions in terms of interrogatories, and about maybe about 18 or 20 request for admission questions.
Yes.
I'm going to object to dropping the deposition.
You what?
I don't object to the dropping the our request.
So now you don't want depositions?
Guys, I'm thinking a little bit more. The,
Well, that's probably good because your motion was going to be denied.
yeah, as a,
So I don't need a response on that motion, Mr. Gannon.
Yes, sir.
The motion to compel this depositions is denied. I would also indicate that at this point, plaintiff can answer the other set should they so choose, as well as a request for admissions or the other set of interrogatories. But I'm not going to allow any further. I think the process is being abused. And so I'm not going to have any further discovery without the permission, express permission, and written permission of the court. There will be no further discovery.
And we do have a set to them that's a couple weeks
To
old.
answer that, but any additional request, there needs to be written permission from the court to do so.
Yes, sir.
Motion in limine.
Your Honor, the motion limited was filed, I think that is, we're gonna withdraw that motion limited, see what plans provide in terms of discovery. And if appropriate, if I remain the attorney, maybe file another, motion limited.
I don't understand why I have this now, if that was. Any response to the motion in limine, Mr. Gann?
I did submit a response to it. I think the timeliness is the real issue here. How would you know what evidence you want to exclude without even knowing what evidence has been produced yet? In addition, there is a federal statute 24-247.6, which does allow landlords additional grounds for termination that were not known to the landlord at the time of the issue. And until discovery is complete, I think this is premature motion.
Well, this motion in limine, I understand they want to withdraw it, but I think we need to make this record clear. I'm going to deny the motion in limine. I think there were only three, right?
Let me draft an order for those two, Your Honor.
No, I have people that will do that
Thank you.
now. The motion to withdraw.
Yes, respectfully requesting to withdraw. There's been a breakdown in communications in regards to this matter. That breakdown has remained for some time. I'm respectfully requesting to withdraw.
Nori, or do you have a response to that?
yes, if I may, sure, I've asked, Attorney Ogletree what specific examples, events, behaviors, words, anything. My part. It was led him to make that decision. That's in a few times the emails. He hasn't provided any specific examples. I usually try to have most of my communications via email. It's a matter of record. So it wouldn't be hearsay, my word against your word and something. So, Ogletree told me that it was going to be teamwork. I said, great, collaboration. So I'd like to be as part of that. I'd like to be in the loop. and I should be with a client here, something very important. And a few conversations took place and few things we hashed out. I'm assertive, but very respectful. And I don't know which one of those things that we discussed between us set him off. I have no idea because he hasn't responded. So about 3 weeks into the session, or essentially the process, which was about 3 weeks ago, roughly, then he decided to withdraw. He said that I wanted to litigate the case, and I was disrespectful and demeaning to him. And he still hasn't provided an example to me. I've never disrespected him. I don't like him. And we have this professional relationship.
You guys probably need to figure it out, and I probably don't need to. Normally, I wouldn't stand in an attorney's way to get out of a case, but you're objecting. Usually that's not the case either. So I'm going to, at this point, go ahead, counsel.
I'm limited in terms of
What you can say. I know.
Yes. I mean, but I have put in writing in regards to this. I'm just trying to think of what I can actually say. There's not attorney-client privilege.
I get it.
My hands are kind of tied of what I can say. I would just say, I think that at this point I may have a conflict with our system. And that's the only other thing I can say.
How soon will we be ready to, I have a final settlement conference on the 7th, already set in this case. So on August 7th.
August,
When?
August 4th is the first.
Is it the 4th or 7th?
Oh, except for the 4th and then the 7th.
4th and then the 7th, right? Okay, gotcha. I think what I'm going to do on the motion to withdraw, and Mr. Editori, I just want to make sure I'm clear on it. You're objecting to counsel's motion to withdraw?
We need to have an attorney.
Pardon?
Have an attorney.
Okay, but you don't need to have this one if there's a problem.
I haven't had a problem. As I said, I communicated and continue to communicate.
Well, maybe you guys can figure that out. What I'm going to do is, when is the discovery due?
We just received another one on Friday, so that would be, you didn't put it in close of discovery.
That was the second one.
That was the second. The first one we've responded to already. I believe we gave theirs to them a couple weeks ago, so probably 14 more days, I would assume, would be when that one's due.
You'd agree with that, counsel? About 14.
Yeah, roughly about 14 days. But I think what he's saying is he's asking for if there's some type of legal aid program that can appoint an attorney.
Well, you just saw him in here. You can go to legal aid. I mean, we'll give you a number to call them, but
We have already contacted them before, a while ago,
and
not recently, yeah. Well, yeah, even a couple of weeks ago when I was wondering what's going to happen, they said that they're not, they don't have the resources for an attorney who's going to be fighting.
all right,
We're wondering if the court could assign a pro bono attorney
I cannot assign an attorney on a civil case.
on a civil case. Oh. Yeah.
I would just respectfully again just request to withdraw. Again, I believe I have a conflict in this matter.
What I will do is I will grant the motion to withdraw. Any notices, discovery, or anything like that are to be sent directly to the defendants in this case at the 939 West Clark Road, number 101, until further notice of the court.
We rescind the first set of interrogatories. Has that already been given to
Well, he's under an obligation to make sure that that they have them. I don't think.
So,
Okay.
so that was shoot out for you.
All
And
right.
Your Honor, just for clarification, I know you've got it set for a jury selection. Is it August, September? At the end of August, I'm going to be out of country. So I just want to make sure we don't miss
I have it set for jury selection August 10th.
August 10th.
Right. August 10th for selection.
How 1 year selection, Your Honor?
Pardon?
How do you run your jury trials? Is it
Very well. Thank you.
I
But
understood. As far as the timing, is it the next month, the next week, the next day?
it can be the next month.
Okay,
We'll work with timing in terms of, I work with counsel. If we select, I work with counsel in terms of timing of the jury selection. Also understanding this being a civil case, the
criminal.
criminal cases take precedent.
Understood.
I would also indicate that's how much is monthly rent?
155, Your Honor.
Okay.
It's a, by the 7-day last week, an escrow order, as well as an order to have no negative contacts with all names.
Yes. So, well, I just wanted to make sure that escrow has been complied with, so it has been thus far. All right. Thank you.
Next question.
Yes.
Pay the May rent into this. I know you said starting as of June, but could we pay that to the courts too? But they didn't take the rent, maybe from us.
We'll never object to them paying more rent to the court. As Park Forest required us not to take May.
Right. So you can pay the maid to the court. That's fine.
I can?
Yep.
Oh, okay.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
That's all yours.
Yes, I can take all.
Huh?
I'll take all.
She's gonna do that. That's yet nothing to do. Who did? Mr. Ogletree provided an order, but I don't like his order. I have interns to do orders,
Okay.
and they do a fine job doing orders. Don't be so shy. Just be like me. Proclaim your greatness. Right. All right. Right?
Mhm.
Okay. It's a consent order.
Yeah.
Okay, then you're okay. You can stay.
Yeah.
Or- no.
Yeah.
Well, wait, I'll call it slow. Is that the one?
Sure hope so.
But if I call it right now, she's in. Well, we have to, no. You know what? I told people what to do. Huh? You think she's staying there? No, I think she took off. You did? Okay, so we got to wait just a minute because, and I told you what you need to do, that if she doesn't show up through those doors in a few minutes, then you got to go find her because I'm not explaining to her parents why I lost their child. What? If she, no, don't check because I'm not explaining it. I'm just not. I don't know where your child is. I'm sorry.
It's a proud moment when the parents get to see the kids working for the court.
Pardon?
It's a proud moment when the parents get to see the kids working for the court.
It's better that they work for and not in front of. You know, that's the way I.
Daughter worked for Ben Graywall, who took down Larry Nasser, so she was fairly on that case. So.
Got it. Where? Doesn't take that long.
He also doesn't know who they are.
Is she lost?
She probably just take her time.
Why would she take her time? I told her.
So after that, resumes, which is going to be this.
Really, man?
Second.
What?
Second.
Oh, you're saying? Okay, fine. I'm just gonna do it. I'm just.
Oh, you want me to go around the.
No, it's okay now because we were waiting for you to go around to the front, and then I thought.
She told me.
I thought, well, I know, but I thought I was gonna have to explain to your dad that we lost you, and I'm not. I wasn't doing it. And then Minori said she's gone. She left the building, and then I didn't know what to do, so I'm just gonna call it. Town Center Place versus Eugene Records. Embarrassing. Yes.
Good morning, Judge Mark Wasbury on behalf of plaintiff.
And sir, your name?
Eugene Rankins.
Thank you. And it looks like the parties have worked out a consent order for conditional dismissal.
Yes, sir. Yes, sir.
All right. And it indicates that you're going to vacate the premises and turn in the keys by August 3rd, 2026.
Yes, Your Honor.
All right. And that's a voluntary move on your part. That's the court's understanding of the agreement. Is that what you've agreed to, sir?
Yes, Your Honor, I did.
All right. Do you have any questions regarding this conditional order of dismissal?
I clearly understand, Your Honor.
Pardon?
I clearly understand.
Okay. And I'm going to sign this, but I do have to apprise you that you have 3 business days in which to think about it. If you think there's some legal reason, some right you didn't assert, or some other reason, then you could move this court to set it aside within the next 3 business days. You understand that?
Yes, Your Honor, I do.
All right. And again, no further questions on it, right?
Sir.
I would also indicate, sir, just so that we're clear on the record, you guys have worked out this agreement. The court did not issue a ruling on this case, right? I'm just signing off on this. That I would indicate that a family member for Mr. Wasbury does work for the court. And so if you don't want me signing this, I'm disclosing that to you. It has nothing to do with anything that I would do, but I'm disclosing that to you. If you want another judge to sign off, I can have another judge sign off on it.
Your Honor, that won't be necessary.
It won't be necessary. All right. Thank you, sir. And it's signed. Thanks, folks, for working it out.
Judge, I hope she wasn't leaving because she was embarrassed of me, but
Well, we'll talk. I think actually I embarrassed her, but that's the way we roll. So, okay. All right. Thank you. You're like, all right. It's like, look at, she's blushing. Can I have the Norman file? Yes. Court has called the case of the people, or not the people, of Stanford versus Norman. Been taking them. I don't know what I've done. All right, state your name, sir.
Bill Stanford.
And Ms. Norman, can you hear us?
Yes, good morning, Susie Norman.
Thank you. All right, this is a time and date for the court's decision on this case. I've listened to the testimony from the parties and am prepared at this time to issue the court's decision. The first finding that I'm going to make in the case is, and I'm doing so because I think the security deposit, well, there are different amounts that are claimed. The leasing agreement clearly indicates that $3,500 was paid as a security deposit. That security deposit, so that the record is also clear, was not held as it should have been pursuant to statute. So there's nothing presented to the court that would indicate that this is an amount held in a separate account for this tenant. Therefore, that in this court's mind, that leads the court to the default position of looking at the leasing agreement, and it was the $3,500 the court will find that was paid or should have been attributed to the security deposit. There are then claims by the landlord, and without getting into whether or not the landlord has properly complied with the Security Deposit Act, I will come to that a little bit later. But there is a claim for damages Holloway and Holloway, which account for $1,090. In looking at that, the court does not, there is no justification that the court sees for the damages that are listed here to be applied to the security deposit, number one, because they're not really damages. Saying that certain things had to be carried away. And the court would find that the plaintiff has not sustained their burden as it regards that claim of the $1,090. The cost for blinds, the cost of the blinds in this case, there weren't really adequate proof per se of all of these blinds having to be replaced in the fashion that they were replaced. In fact, it only looks like there is 8. There is also this $250 labor charge, and it's unclear to the court because none of the people who did this labor, with the exception of the plaintiff in this case, has said in some ways that he did some of the labor. But I don't have any of those individuals there. I don't have a receipt or anything along those lines for what was paid to them. And so I will allow the cost, although it may be a bit high, I'll allow the cost of the blinds plus obviously something had to be done, but I'm not allowing the $250 in labor. I'm only going to allow $150 in labor. So that's, you're going to need to keep track of these numbers for me. So that is 200 instead of 361.13. It is going to be 261.13 that Ms. Norman might owe for the replacement of the blinds. The window glaze removal, while I think that's a bit high, I will allow the $100 for the window glaze removal. I will, and I'm not going to have a dispute. I did see some screen damage to the premises, so I would allow that $100 for that. The replacement of the doors at installation is a huge problem. because the cost that's attributed for these is $1,775 plus materials. So the doors themselves, the landlord has estimated at $211.47. But then the labor charge seems high and ridiculously high, quite frankly, at $1,775. Because it's so high, and I can't even figure out what it specifically is for, I'm going to disallow the entirety of that, with the exception of the material costs, which seems reasonable. Cost of the new locks to the premises, that also is a problem, because I'm not sure, again, where this $100 an hour is coming from. I don't and didn't have, as I saw, a receipt for those locks. And I'm not sure that the locks needed to be changed, or they could have been rekeyed for a lot less than these costs of new locks. I will, however, give the defendant $200, which I think is generous, giving some benefit, give the plaintiff that, with some benefit to giving him some benefit that the locks even needed to be changed. There is a water and sewer balance. Again, I didn't get anything on this, and I don't know that that was due. It just says that. And I'm not going to allow it. Cost of the fridge drawer, I was not presented a receipt for that. And so I'm not going to allow that. There is this writing on the walls, chalkboard, furniture, solvents and paint that he's charged $875 for. I see some of the pictures. I'm having problems with these labor charges that the defendant is, or that the plaintiff is putting in here. And so I'm only allowing on that, I'll allow $500 for that. I think, again, that may be a bit of a high figure, but obviously there is some cleanup or some damages in that regard. This plumbing repair costs, the dry out flakes, the setup and the dryers and all of these things, I just don't think that's attributable to the plaintiff. And so the plumbing parts and repairs, because the landlord has to take care of the premises. Those are fixtures more than anything. So I'm not going to allow that. I'm not allowing the cost of dry out moisture. There becomes a problem in the unit, and the landlord is going to have to dry that unit out anyway. And that. Then there is this sort of overall cost of $1,200 for the cost of carpentry, drywall, painting. Now, what's interesting to me is there's like a double dipping, because previously in the list, there is a solvents, removal cost of writing on the walls, and that's not included in there. but I get to this particular item and there is just $1,200. I don't have a breakdown of what's drywall, what's painting. I don't even have, is this labor? Is this materials? I have nothing. And so I'm not going to allow that. So I need 1261.13, $200, 211.47, and then $700 brings me to what?
$2,372.
2,000. Say it again.
$372.47. You said 1261.
Oh, it should have been 261. So you got to take 1,000 off of that, right? So it should be 1372. And how much?
It should be
1372. 60.
1261.13, correct?
Got it. Yep. And then take that figure, take 3,500, subtract that figure out.
From 3,500,
Yes, ma'am.
$2,127.40.
So based upon the court's finding regarding the damages, the like, and that the plaintiff did not keep the security deposit as required by statute, I will also indicate that I am not pursuant to the Security Deposit Act, doubling the security deposit for wrongfully withholding it. I am going to order, and I am going to order that the 1372.60 be subtracted or deducted from the security deposit of the $3,500, and I will award a judgment to the defendant, Miss Norman, against the plaintiff in the amount of $2,127.40. And Ms. Norman, you need to submit to the court a judgment in that amount. You understand that? I can't hear you, ma'am.
Actually, I do not, but I have my notepad here, so I'll make notes and follow your instruction.
You need to submit a judgment to the court, awarding a judgment in your favor as against the plaintiff in this case in the amount of $2,127.40.
2127.40. Okay.
Yes, ma'am. Thank you.
Thank you.
No, I didn't write anything. All right, Mr. Fink, who else? How many do I have left?
You have two left. You have the settlement conference with Mr. Fink, and then you have a trial pro se.
Who are they? Who are they? Are they here?
Yes, they are both.
They're both here?
Yes.
Okay, ladies, hold on. I've been going, hold on, who are you?
That's Mr. Fink's.
That's Mr. Finks. Okay, so you guys are what I've got left. See, I've been going for a little bit. I'm gonna take a brief break. I promise I'll get you out of here back into the heat in no time at all. But I gotta take a brief break. All right, folks?
Can he pay all of this today or does he?
He cannot, Judge.
How much does he have?
3 to 4 months.
Jack, I'm gonna set you on a payment plan. You make $700 to $900 per week. How much can you afford to pay weekly? I don't even need that. We'll make it $65 a week. You get paid every Friday?
Yes.
I'll make it starting on July the 6th, okay?
Thank you, Judge.
And the Monday, each Monday thereafter until paid in full. If you don't have the money, it's not a problem. You call the court, we'll go through Zoom, or you can walk in here on or before any due date at 8:30 and I'll be happy to give you an extension. Do you understand that?
Yes.
Okay.
Thank you,
You'll
Judge.
meet with probation. Good luck. Thank you. People Against Priority Waste. 26 SO 25034. Good morning. Your appearance, Ms. Tremblay.
Yes, good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
How are you today? Good?
I'm good. How are you doing?
Not too bad. You're going to plead to overweight. You're authorized to enter this plea on behalf of the company with agreed upon fines and costs of $1,000, correct?
Correct, Your Honor.
That charge of overweight, responsible or not responsible?
Responsible.
Please accept it. Fines cost of $1,000, pay by July 30th. Have a great day. Thank you.
You too. Thanks.
Danielle Shante Mosby. 26M692120. Okay. Ms. Mosby and Trooper Brown, I need you to start your videos and state your name, please. There you go, Trooper. Good morning. Your name?
Good morning. I'm sorry.
Okay, hang on. Wait, come on back, Ms. Mosby. Unmute now.
Yes,
And
sir.
tell me your name, ma'am.
My name is Danielle Mosby.
Good morning to you. Can you just stop walking, find a place, please?
Yes, sir. I'm getting to the table right now.
Trooper, your name?
Trooper Brown, Michigan State Police.
All right. Is there any offer on this, Trooper?
If Miss Mosby's record allows, and
I'm going to give you what her record shows. She had an operating while impaired in 2025. And then there were license sanctions. And then she had an implied consent refusal on that. So she was suspended between February of 25 and February of 26. Other than that, it does not appear as though she has anything else on her record.
would be open to offer impeding traffic if the courts would be okay with it.
You want to plead to impeding traffic, Ms. Mosby?
Is that lesser than what I had?
That's 0 points and it won't go on your record. 75 and a 70 is 0 points, but it would go on your record.
Yes. Yes, Your Honor.
You want to plead to impeding?
Yes, Your Honor.
All right, to that charge, responsible or not responsible?
Responsible.
All right, so with what you have, that's a nice offer of him. I'm going to accept the plea, 170. You can go online and pay that today, okay, ma'am?
Yes, Your Honor. Is it possible? I'm unemployed right now. Is
When
there
can you pay it? Just tell me when you can pay it.
like a payment plan I can get on?
Tell me when you can pay it, ma'am. I got a lot of.
Pay like $15 right now. I live in Detroit. I travel.
I know. Just listen to me. When do you think you can pay this in full?
170. Can you give me like 3 months?
Ooh. Well, you're asking for a lot, but I'll tell you what, I'll have you pay $25 bi-weekly.
Okay.
Bi-weekly. So every other week, and I'm going to start this beginning on July the 17th, okay?
Yes,
Now, if you don't have the money on any one of those dates, you call the court, request an extension. I'll go on Zoom with you, or you can show up here at 8:30 in the morning, whatever's easier for you, and I'll be happy to give you an extension, okay?
Yes, Your Honor. I appreciate it.
Just don't ignore me, though. You understand what I'm telling you?
I understand, Your Honor.
Have a great day. Good luck to you.
Thank you.
Nicholas William Blum, 26M6 Trooper, your appearance again, please.
Trooper Brown, Michigan State Police.
Mr. Blum, your name?
Good morning, Your Honor. Nicholas Bloom.
So he has nothing on his record. So do you want to offer impeding?
Yes, Your Honor.
You want to plead to impeding, Mr. Blum?
Yes, Your Honor.
Sorry, it's Bloom, right? You said?
That's correct.
Okay, Mr. Bloom, to the charge of impeding traffic, which is 0 points, it won't go on your record, responsible or not responsible?
Responsible, Your Honor.
Got nothing on there at all. 150 is your total. You can go online and pay that. You're all set, okay?
Thank you, Trooper. Thank you, Your Honor.
Good luck. Thank you. Jesse Wade Bryant, 26 M694-801. Mr. Bryant, you have to, there you go. Unmute and tell me your name, sir. Mr. Bryant, you have to unmute bottom left-hand corner of your screen and tell me your name, please. There you go.
Bryant,
Say it again because I only caught Bryant.
Jesse Bryant,
Your name again, Trooper?
Trooper Brown,
Jesse
Michigan State
Bryant.
Police.
oh,
All right. I have an August 05 operating while impaired out of this court. I have a November 17 operating while impaired out of Dearborn Heights, a 23 speeding and a 24 speeding. He's charged with 85 and a 70. What do you wish to offer, if anything, here?
Be willing to offer 1 to 5 over, Your Honor?
Yeah, that's what you, oh, okay, you wrote him for 11 to 15. So if you plead to 1 to 5 over, sir, that's 0 points, but it will be added to your traffic record. Do you understand that?
yeah, I understand.
You want to plead to 75 and a 70, or do you want to go to a hearing on the charge of 85 and a 70, which would be a 2-point violation?
I'll do the first one.
So you plead to 75 and a 70, limited access?
Correct.
Do that charge, responsible or not responsible?
Responsible.
All right, you got to slow down, sir. I'll accept the plea. 190 is your total. You can go on 33court.com right now and make your payment, okay?
Okay, thank you.
And you have the money to do that, right?
Yes.
Good luck. Thank you. Junior Finke, Junior Santonio Finke, 26M6921112. I have a B and a C file here.
Judge, he paid the A case.
Oh, he did? Okay, where's Mr. Finke at? Mr. Finke, state your name, please.
Hello, Your Honor. I am Junior Finke.
So he paid already. You charged him with 5 over, limited access, 75 and a 70 on I-75. He paid that one. And then he's got an expired plate and a no proof of insurance charge. The only thing he has on his record is a case from 2000. No, that's the only citation he has, is the one that he paid. So what do you want to do here?
You willing to dismiss the no proof of insurance if he takes the expired plate?
Do you have valid insurance now, Mr. Finke?
I do, and my plates are also valid, Your Honor.
Okay, so he's offering if you plead the expired plate, he'll dismiss the no proof of insurance. You want to do that?
Yes, Your Honor. I was at fault. I'll take whatever is given to me.
To the charge of expired plate, responsible or not responsible?
Responsible.
All right, I'll accept the plea to expired plate. He's dismissing the no proof of insurance. That case is dismissed. 135 is your total. That's on the B file, expired plate. And I'm dismissing the C file, no proof of insurance. You can go online and pay that at 33court.com, okay?
Honor, thank you.
Have a good day. Thanks, Drew. Oh, you got another one, McGee. Delicia Lachey McGee, 26M6922200. All right.
Judge, I don't have her on Zoom.
Oh, she's not here. Trooper, your name?
Trooper Brown, Michigan State Police.
She didn't show up. She was given 15 minutes. This was scheduled for 8:45. It is now 9:18. Defendant is responsible as charged by default. So I will go ahead and enter that judgment. And I think that's it for you, correct? Oh, you got
He has more.
Should have 3 more.
What time are those scheduled?
9 o'clock from my understanding.
9:50.
Good. Well, it's after 9:15, so we can call those now. Samantha Turchak, 26 M70744. Ma'am, you have to start your video and state your name, please.
Oh, hang on 1 second. Sorry. Why did this not work?
You're good now.
Oh, I'm good. Okay. Hi, Samantha Turchak.
All right, she's got a clean record. What do you want to do on this one? Operating while texting.
I was
If she has, oh, sorry, go ahead.
Go ahead.
If she has a clean record, I'd be okay with impeding traffic so it's not on her driving itinerary.
Ma'am, were you using your handheld device? Why are you doing that? I hate that. I see people going all over the road. I sometimes think that's as bad as drunk driving, if not worse.
I'm not going to do it again. I was on the phone. I was actually texting a patient and I won't do it again, sir.
What do you do for a living?
I'm an RN. I'm a home care RN and I shouldn't have been on my phone or texting. So I apologize and I won't do it again.
Nice to see somebody admit they're wrong.
Yeah.
All right. You want to plead to impeding?
Yes, please.
Just saved yourself about $15.
Okay, thank you.
Deducted yourself. For the charge impeding, responsible or not responsible?
Responsible.
Is accepted 185. You can go online and pay that, okay?
Thank
Good
you.
luck. Thank you. Caleb Partial Richmond, 26M708027. Yep, he should be here. Caleb Richmond. Come on in, Mr. Richmond, please.
Good morning.
I done now. Oh.
Your name, sir?
Oh, okay.
Caleb Richmond.
All right, let's see. He's got nothing on here, Trooper. He's got just 75 nothing on his record at all. You charged him with, it was 75 and a 70 limited access. What do you want to do on this one? Oh, you're muted. There you go.
I would be willing to offer impeding traffic for him. I remember he was respectful.
Points won't go on your record, Mr. Richmond. You want to do that?
Can you repeat that?
He's offering you to plead to impeding traffic. You can either plead to impeding, that's 0 points. It won't go on your record. I'm going to fine you. Or you can go to hearing on the 75 and a 70. If you lose, that's still 0 points, but it would go on your traffic record.
I can plead guilty.
You want to plead to impeding?
Yes.
The charge of impeding traffic, responsible or not responsible? You plead responsible, sir?
Yes, sir.
I'll accept the plea, dismiss the speed. 150 is your total. You're all set. Have a good day. DMI Logistics, bring in Mr. Levitt, if you will. 26S118461, A and B and C.
Good morning, Your Honor. Michael Levitt, P45336. I represent DMI Logistics.
All right. So you're going to plead to overweight with agreed upon fines and costs of $3,500, right?
That's correct.
And then you're also going to plead to over height, over width, and over length, right?
Yes, my understanding was that the entire fines and costs would be the $3,500 for all three charges.
Well, then how about if I make the overweight 3,100 and I'll make the other two 200? Fair enough?
That's excellent, Your Honor. Thank you.
To the charge of over width, responsible or not responsible?
Responsible.
And to the charge of over length, responsible or not responsible?
Responsible.
That's kind of the way I read it too, but I wasn't sure. So I'll go ahead and accept the plea, $3,100 on the overweight, $200 on the remaining two civil infractions, all payments due by July the 31st. Okay? You are all set.
Thank you so much, Judge. You have a good holiday weekend.
You too. Thank you very much. Bye now.
All right.
All right, Trooper, I'm coming back to yours now. Jacob Jeffrey Soblo, 26 M71880. Where's Mr. Soblo? You have to start your video and state your name. There you go. Your name, sir?
Jacob Sablo.
Trooper, your name?
Trooper Brown, Michigan State Police.
So I don't know. He was involved in a crash in March 24. Hazardous action, unable to stop an assured clear distance. Here he's charged with 75 and a 70, limited access with the 80, but you clocked him apparently at 85 and a 70. What are you offering here?
I'd be willing to offer impeding.
You want to plead to impeding traffic, sir?
Yes, sir.
That's 0 points. It won't go on your record. To that charge, responsible or not responsible?
Responsible.
Plea is accepted to impeding. The speeding's dismissed, 160. You can go on 33court.com and pay that now, okay?
Okay, thank you.
Good luck to you. Mustafa Hyder. There you go. Come on up here. 26 M707959. Your name?
Mustafa Letters.
All right, so he's got violation of graduated license permit, October of 20. He's got careless driving 21. That same incident, it looks like violation of graduated license permit. Then he had a speeding out of Dearborn Heights in 22. Another speeding out of out of Westland in 22. You got a heavy foot. Another speeding out of Dearborn Heights in 22. Another speeding out of Dearborn Heights in 22. You got 2 tickets 2 days in a row. You know that? Then you got another one, no option 22. Disobey traffic control device in 24. Careless driving in 25. I can't do anything for him on this. You charged him with 75 and a 70. You can either plead responsible or you can go to hearing.
Responsible.
According to our chart, that's 135. I'm not going to raise that, although I should. You got to slow down. What are you doing? Who's paying your insurance? You? You must have to have 3 jobs to take care of this. Come on, I'm serious. Slow down. What's the hurry?
I'm trying to clean up my driving.
You better try harder. It's going to take a long time. Good luck. Go down the hall and pay your 135 and you're all set.
Thank you.
A&M, I think, is that it for you now, Trooper? You got another one?
I
No, you
believe
got
that
another
would.
one. Dion
have
Reed
another one?
Williams Collins. Dion Reed Williams Collins, 267-701-943. Dion Collins. Is she? Oh, Ms. Collins, you have to start your video and unmute. You just muted your video. Is A&M Carriers here? Kagazi? Against Dion Reed Williams Collins, 267-701-943. Good morning, ma'am. Your name?
Dion Collins. Can you
Trooper,
hear
your
me?
name?
Dion Collins.
No, Trooper, your name?
Oh,
Michigan State Police.
I didn't catch it all there. I kind of did there.
Trooper Brown, Michigan State Police.
She's got a clean record. She's going to explain to me why she was driving 100. She must have been having a heart attack. You weren't having a heart attack, were you, Ms. Collins? Come on now. What are you driving like a maniac for? I don't.
so,
What do you?
so it
Hang on.
wasn't 100. Me and Mr.
Hang on.
Trooper Brown. Oh,
Let me ask him a question. What do you want to do on this? She's not had a ticket.
He's got a clean driving record. I would offer impeding.
Ms. Collins,
that's what I would like because
why are you driving like a maniac?
so me and the trooper, we were kind of going back and forth. I was doing 85. He said, I'll give you 85 because you caught up with me. I was speeding. So I did not know in all transparency that he was a trooper. I thought he was a regular biker. So when I seen him, I sped up to wave at him and smiled at him. And then he put his lights on me and I was like, oh my God, I gotta be the biggest
Wait,
idiot.
because you're driving by a trooper going 100. I know you're telling me 85. Was this a laser, a radar, or what was it?
I had her on my rear radar coming up to me at 100 and I was going actively 85. So I had paced her at 85 as well. That was part of my tracking history for this.
Collins, to the charge of impeding traffic, responsible or not responsible?
Responsible.
You don't usually drive like this, do you?
No, I was really being silly, Judge. I
So?
did not know he was a police officer.
Well, I would
thought he was
think
a
you
regular
wouldn't have thought
biker.
he was a police officer if you're driving by him going 100 and smiling. I got to charge you a little more than I usually do, but I can't. I'll take your plea to impeding. I'm fine with that, but probably a little too lenient. 175 is your total. That's only because you got a clean record. You can go on there and pay that. I'll dismiss the original charge. You seem like a very pleasant lady, but please slow down, okay?
Thank you.
Best of luck to you. Trooper, I think that's it for you now, right?
Yes, Your Honor.
Have a great day. Thank you. Good luck, ma'am.
All right,
A&M Carriers, Inc., 26S118149. All right,
Good morning.
counsel, good morning. Your appearance.
Rami Hijazi, P82830 on behalf of A&M Carriers.
How you doing today? You doing all right?
I'm doing great, Your Honor. Thank you for asking. Hope you are as well.
I am. Thank you. You're going to plead to overweight with agreed upon fines and costs of $4,900, right?
Correct, Your Honor.
All right, and you're authorized to enter that plea?
Fully authorized with consent. Yes, Your Honor.
To the charge of overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. Fines cost $4,900, paid by July 30. Have a great day. Thank you.
Have a blessed week. Bye-bye.
Who has a case out there ready for me? Anybody? Mr. Dubin, what are you here on?
Good morning, Your Honor. I'm just waiting. So Nor just got there. I was put in the breakout room with the other prosecutor. I just need a breakout room with Nor when she's set up, Your Honor. I'm on Ryan DM.
Okay. Okay.
I'll put you in a
anybody
room
else-
right now.
Thank you guys so much.
Ms. Tucker, what case are you here on?
Morning. I was just assigned to a Chadwick Walls.
Do you need to speak with him, Miss Tucker?
Yes, please.
Okay, I'm going to put you in a breakout room.
Okay. And Mr. Barrow, what do you have?
Morning, Your Honor. I have a civil infraction today where we're able to reach a resolution for
Have you already
Secure Express.
Have you already talked to the prosecutor?
Yes, Judge. We resolved it.
Do we have the file in? We don't have the file. As soon as I get it, I'll call it, okay?
Yes, Judge. Thank you.
No problem. Mr. Walsh, we're putting you in a breakout room to speak with your lawyer.
Oh my God. Hello?
Mr. Walls,
we-
join the breakout room on your screen.
Join the breakout room.
Is I'm in the right one?
Look
I
on
didn't
your
hear-
screen and you can join the breakout room. There he goes. Mr. Bashiga, what case are you here on?
Hello.
Hi, what case are you here on?
Done. It's from
It's for Clinton.
yes.
Yep.
Oh, we have your last name as Clinton. Is that correct?
Yes, it's the,
Okay.
yep, it's Michigan.
That's yours. Okay.
It's mine. I just had an opportunity to speak with the prosecutor and we've come up, I think, with a resolution we'd like to propose, but we're going to need an interpreter to be able to put it on the record.
Okay. I am going to just change his screen name so we know who he is.
Perfect. Thank you.
Mr. Dox, did you join the breakout room?
Yes, hi, good morning.
Hi. Do you need to talk to your client next?
Yes, please.
Okay,
Breakout
let me
room.
put you in a breakout room.
Thank you.
Actually, you know what, Your Honor? Sorry about that. I'm just looking at my calendar here.
Go ahead, take your time.
Yeah, if the 21st isn't too far away, if we can do that, that'd be great. But if not, I'll make it work. You know
On the
me. I'll
14th,
make
you
it-
mean?
Yeah, I have a lot of sentencings on the 14th. I was gonna see if we could do the 21st on that Tuesday.
Let me ask you a question. Are those in the morning?
On the 14th, Your Honor?
Yeah.
Yeah, they're all in the morning.
Well, I could, Lisa, is there a reason we can't do it at 1 o'clock on the 14th?
Let me double check.
Oh, wait, I'm so sorry, Your Honor. I see it's scheduled for the 14th at 11. As long as it's okay if I'm possibly just like running a little bit late or it goes to the like 12, that's fine. If it's the afternoon, no problem at all.
Judge, you have an afternoon flat rock docket that day.
You think this one's likely to go?
Yeah, I do, Your Honor. But again,
Let's
with
do it.
11,
I'm gonna.
I can
hang
probably
on.
swing 11.
Are you sure? Because what I don't like is I don't want people showing up at 5 to 12 and I've got a 1 o'clock docket. I want to get out of here for an hour and I certainly want my staff to.
Yep.
So if I can either give you, I can either give you 12:45 on the 14th. Or I can do 1 o'clock. I mean, I guess, yeah.
Oh, 12:45 works perfect.
12:45, July the 14th. That's when I'll make it. Okay.
I appreciate you very much. Oh,
That's the day you have the afternoon flat rock docket.
No, I know, but he's going to be here right and ready to start at 12:45, right? The docket doesn't start till 1. This won't go more than half an hour, will it?
no, I don't believe so. And I can even be there at 12:30 or earlier, to be honest.
Okay, good. Good. We'll make it 12:45. Try to get here early, talk to the prosecutor, and we'll go from there. Okay.
That's perfect. My sentencings are in like Livonia, so they're close enough for me to get there, no problem. So
Okay, great. Thanks.
I appreciate you just always. Thanks, Your Honor. Great to see you.
You too. Secure Express LLC, 26S118475.
Morning, Your Honor. Ali Barrow, P85907, appearing on behalf of the defendant. Requesting his presence be waived. I do have permission to enter a plea on his behalf.
All right, you're authorized to enter this plea on the behalf of the company to Overweight, correct?
Correct, and to a reduced fee to $6,000, 30 days to pay, Your Honor, or get an
On
appeal.
behalf of the company to the charge Overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted, $6,000 paid by July 31. Thanks.
Thank you, Judge. Have a great day to you and your staff as always. Bye-bye.
You too. Thank you. Bashiga Bowija Clinton. This is 2-6M680000.
Morning, Your Honor. Brian Kelly on behalf of the defendant.
Are you the football coach that used to coach at Notre Dame? I'm just kidding. Where's Mr. Clinton at?
He's here. He's here remote, Your Honor. He's on, I think he's turning his camera on. We've had an opportunity to speak with the prosecutor, and I think we would be able to resolve this, but I believe we're going to need an interpreter, French interpreter, so I can get through a couple questions and probably the advice or rights.
Did I? I'm surprised. Did I? I arraigned him. I'm surprised I didn't.
And I thought we were going to be okay with after we went to the arraignment, everything went fine. And when I was talking to him today, I realized to get through it, it's probably going to be a little more clear for
Get
you.
a French interpreter. Mr. Clinton, can you tell me your name?
My name is Bouija Bashiga Clinton.
I'm going to set this for July the 14th. And we're going to get you an interpreter. What time are we doing on this one, Lisa?
10 o'clock.
At 10 a.m. Okay, counsel?
Thank you so much, Your Honor.
Have a good day. Good luck,
too.
sir.
Good
Did
to,
you say
have a good
French
day.
interpreter? I'm sorry, French?
Yes.
French, please.
Okay, thank you.
July 14th. Thanks.
Thanks.
Uh,
Mr. Clinton, we're all set. Have a good day.
Mohammed Alamara, 260-816-656. Mr. Walls, I'm going to ask you to take the cigarette out of your mouth, please. I know thank you. Where's Mohammed Alamara?
Right over here, sir.
Your name? Tell me your name.
Mohammed Alamara.
Says you have a fishing license. They're dismissing in the interest of justice. I love that, huh, Mr. Graziani? In the interest of justice.
Thank you.
Dismiss motion of the plaintiff. You're all set. Prosecutor, good luck.
Thank you very much.
Hussein Asarov, 26D816657. Where is Mr. Asarov? Good morning, sir. Your name?
Hussein Al-Saraf.
We're adjourning this 2 weeks so you can get a license.
Yep, sounds good.
July 14th, what time, Lisa?
Any time works for me.
Well, good. Thank you. I was asking my judicial clerk, but we do want to
9:45.
accommodate all participants here.
Okay.
Okay, go ahead. Go ahead.
9:45.
Okay.
9:45. Okay. Good luck to you. We'll see you then. Thank you.
Okay, thank you, Your Honor.
All right. Have a good day. People against Griffer. Ryan Joseph Griffer, 26B711925.
Good morning, Judge and staff. John Graziani, I bring on behalf of Ryan Griffer, who is to my left. Please identify yourself, sir. Ryan Joseph Griffer. We're seeking a 1 week adjournment, Judge.
Lisa, who is sitting for me then?
Judge Hessen is handling all PCCs.
Yeah, so I'm not going to be here. So I'll tell you what I'll do. Can you call Ms. Holloway?
There's a bit of an issue, Judge.
No, I get it. Call Ms. Holloway a second. I could adjourn the final pretrial to July the 14th. Here's what I'm thinking. And then set the trial for the following.
That would be great, Judge.
Let me just check and make sure she doesn't have any conflict with witnesses or anything like that, okay?
Absolutely.
So I'm going to ask her, conference room machine. I didn't get a sheet.
I just called her. I didn't get a sheet either, but she's on her way in.
Did I ask your name, sir?
Yes.
Okay. Just give us 1 second here.
What do you got?
I thought Ms. Holloway was on this one.
Yeah, Miss Holloway.
Yeah, what conference room is she in?
Oh, fine her. Yeah. She's in the, I already know where she's.
I can go get her. She's on the.
Is she in two?
She's on the possible to me.
Yeah, Ms. Ismail, I don't need you on this. This is a domestic. I just want to make sure.
I was gonna say, I haven't talked to Attorney Graziani to the case yet.
What's that?
Talk to Attorney Graziani.
I'll be talking to you.
Yeah.
Let me talk.
What are we doing here? Can I hand this to you, please? Thank you.
She's on it.
I can go grab them.
Yeah,
Thank you
please.
so much. It works out well. Just to.
How you doing, Ms. Holloway?
Yeah, the people, 86528.
You didn't show up. What time did you show up today?
9.
What time we start our dockets?
I know.
It's okay. It's fine. Try to get her early. I went. It's all right. I was impressed with this young lady trying her bench trial. I don't know if she did. Why are you shaking your head side to side? You did a very nice job.
Oh,
It's what?
Tough Friday.
Yeah, but she did a nice job on this. I was really impressed, Mr. Graziani.
That's why I don't want to go to trial.
I know she's tough. She's going to be a really good lawyer. I'm impressed. I'm not easily impressed
It's a
either.
good prosecutor's office.
Okay, so I'm thinking about taking he wants to adjourn the pretrial 1 week. I'm not going to be here, so I'm going to adjourn the pretrial 2 weeks and adjourn the bench trial from July the 14th until the 21st. I want to make sure that's not going to create a problem for you.
That works.
Okay, so we'll make it July 14th at, we'll just make it at 9 o'clock. Bench trial on the 21st, Lisa,
At 1.
at 1. Okay? All right, I know what I said. You did a nice job. I was impressed. Good luck, sir. We'll see you here in a couple of weeks. Thank you. Lucas Bowman, 269 709-278P.
Ready, Your Honor. Good morning. For the record, Trevor Garrison for Mr. Bowman. Your Honor, we're respectfully requesting an adjournment of the pre-hearing conference.
You guys can't, what are they doing here? It says pre-formal officer stated a case was submitted to prosecutor for misdemeanor charge.
Exactly. That's right.
Well, I mean, I'm not going to wait for them to go through that. They either need to. Oh. I don't know. Did you talk to the prosecutor about this, Mr. Garrison?
I did.
What is she saying? Have they submitted it? Are they going to authorize on some misdemeanor charge or what?
Well, I don't think she knew that it was that the civil infraction was dismissed. I told her that, and so that's another reason why we're requesting the postponement. I don't believe we'll be able to resolve the civil infraction anyway. They're indicating that they have no authority to dismiss it, given that my client had a CDL. A dismiss or amend. So it's likely it'll go to formal hearing.
Well, I'm going to adjourn the formal hearing then. I'll set it for, we'll set a formal hearing. So you have to be in person though, okay? July the 14th at what time, Lisa?
Well,
I'm not going to put this off much longer. I mean, I get it. I'm not saying I'm a fan of that law, but that's the policy they take. So.
No, I understand. I'm out of town on the 14th. Do you have any other days besides Tuesday? My Tuesdays are jammed for the next few weeks.
This is a state prosecutor and they're only in here on Tuesdays.
Okay.
I'll go to the 21st. That's the latest I'm going.
Well, I'm going to be in Bradenton, Florida anyway on that day. I'm sorry.
You said you weren't going to be here on the 14th.
Right. And I'm also gone the following week. I'm in Colorado on the 14th.
Are you really going to have a formal hearing on this? I mean, if I get guys telling me this, then they come in and plead and, I'm not going to. I don't want to do that. I'm just telling you, if I'll go out of my way to set this later for you, if you're really going to have a hearing, but guys don't have hearings on these.
Well, I mean, my client, this is his livelihood. I mean, having a.
No, listen, I'm not, if you're going to have a hearing, all you got to do is, no, Judge, we're definitely going to a hearing.
Right. Well, I mean, yeah, we have some dash cam. And that's a decision I'll talk to my client about. But
all they got is 70 to 65. I just can't adjourn it much longer is all I'm trying to tell you.
I understand, Your Honor. Well, I mean,
what day can you do on a Tuesday? I'm not taking it to August. I promise you that.
Well, that was what I was going to suggest, August 18th, but.
No way. No.
Okay. Well, then,
I could do an afternoon for you. I'll do that for you. Where's your office at?
Royal Oak.
I can't go that long. What's wrong with, you're going to be gone the week of July 14th and the week of July the 21st and the week of July the 28th?
We didn't, no, not the 28th, but the first 2 weeks, yes. How about August 4th in the afternoon?
What's that?
Is August 4th in the afternoon?
Why can't you do the 28th?
I have a pretrial in Oakland County Circuit Court in person at 8:30, and then I have a Clinton Township matter at 1.
Call in the prosecutor, will you? And you're gone for 2 weeks on vacation or what?
No, the first week is well, kind of. The first week is a vacation for 3 days, and then the next week is a soccer camp in Bradenton, Florida.
Well, so I got it. You play soccer or your kid? You mean?
No, my daughter does.
I'm not going August. I can tell you that. So you're gonna have to figure out something.
Well,
counsel your appearance.
Good, morning, Your Honor. I'll say it's 9:30. People be 8:00.
I don't want to adjourn this forever. He wants me to set it for August 18th. I'm not going there. This is the civil infraction, 11 to 15 over, but they only wrote them for 5 over, right? They only wrote them for 5 over. This is.
Is that the one with $60?
Yes. Yes.
And you were already made aware that that question was dismissed because it was going to be submitted as a misdemeanor in the law of this.
Count 1 was, right?
Yes, not 2.
Right.
It's a CDL driver. It's a CDL driver. I didn't let it sounds not here. You said anyways.
That's still limited access, right?
Does it say limited access on there?
It doesn't say limited access, but they never say limited access. This must have been, they wrote them for 70 and a 65 and I-75.
Yeah, they wrote it as they wrote it as exceeding speed limit. Those ones are tricky. They don't give us much room to do anything.
No, I know because of that masking law, which I don't know why they.
I don't want to get.
I'm not blaming the prosecutor's office. At first, I thought maybe it was them, but it's not. I read the masking statutes, and I don't know.
Well, if you know, I have a strong opinion on that.
I don't, yeah, but she can't violate laws. She's not going to do that. They're not going to do that.
No, I understand. It's neither here nor there, I guess, but it's just, I don't think it prohibits plea bargaining. It's just masking I think it's different, but that's for, I guess, another day.
You can reduce the charge to something similar. So non-moving violations can get reduced, but moving violations are not allowed to get reduced unless it's something similar. So if I had like an 11 to 15, I could reduce it to like a 6 to 10 or something.
And they only wrote them for 70 to 65. I'm not sure why the jacket, unless somebody made a mistake, Lisa, says 11 to 15 over.
It was a mistake. I can assure you, we have the dash cam. That was a mistake.
Well, wait a minute. Well, I'm saying an internal mistake by us because somebody put on the register 11 to 15 over. They only wrote them for 70 and a 65.
I did see that, yeah.
I don't know what the actual speed was. They usually put it on here. They didn't.
It said 70 and 65 right under the ticket, under the portion with the charge, under the count.
That's what they charge, 70 and 65.
Right, and exactly. And
but
then,
but I don't see what the actual speed was, unless he's saying he was only going 70 to 65.
It was going 70 to 65. Typically, when I see speeding tickets, sometimes they'll put 72 and a 65. The numbers will change. It doesn't stay to that 1 to 5 range. It doesn't stay to that 5 range.
Right.
I believe he was going 5 over.
I don't know what to tell you guys. I'm not adjourning this talk. So,
all right, if you know what, I have another thought. If Your Honor, could I join the breakout room again and I'll talk to the prosecutor? All right, thank you so much.
Yeah, sure.
Thank you.
Thank you. Transport. Amex Transport 26S 118-447.
Respectfully, Your Honor, Sam Richard Dollar, P62186, appearing on behalf of Amex Transport with the authority to enter into today's plea agreement.
Good morning, Mr. Jadal. This is going to be a plea to overweight. Fines and costs, 7,000, correct, and 30 days to pay.
Yes, Your Honor.
All right, and you're authorized to enter that plea.
Yes, Your Honor.
To that charge of overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. Fines cost 7,000, paid by July 31. Okay?
Thank you, Judge.
Thanks a lot. Have a good one. Becker.
You and your staff also.
Aaron Michael Becker, 26M702004. Where's Aaron Michael Becker? Aaron Michael Becker, you need to start your video and state your name. There you go.
Becker.
I don't have Trooper Zagalonis out there, do I?
Hold on one second, Your Honor. I gotta roll my windows up and turn the truck off. All right, I'm here.
Is Trooper Zagalonis out there, Lisa? I don't see him.
No, he's not.
You're a winner today, sir. The officer failed to appear. Case dismissed. I gave him 15 minutes. It's now 10:06, and this was scheduled for 9:45. Slow down a little, please. Your record doesn't look that great. I know it's a prohibited using.
My record don't look great.
Don't be doing that, though. You know what I'm saying? That's dangerous. I see. Well,
Yeah,
I
Your Honor,
didn't look
so-
that closely. I just saw some citations on here. Let me see here. No, it doesn't look that great. I mean, no, it doesn't. I mean, you haven't had anything since 22. That was a hazardous action. Just be careful. No use of cell phones, okay?
Yes, Your Honor. And I just want to let you know, I am a truck driver. I use a headset while I'm in the truck. That day, I just picked up the phone the moment he drove by in my personal vehicle, and I apologize.
Have a great day. It worked out for you. Good luck. Case dismissed.
Thank you. Have a good day.
Thank you. Mohammed Kari Otba Benaziz, 26 M653046. Where's this gentleman at? There you are. Your name?
Mohammed Benaziz. Hi.
Trooper Reem, your name?
Mohammed Benaziz.
No, I heard you. Trooper, your name?
Trooper Nicholas Ream.
Can you just get a little closer to the device? He's got a clean record. You wrote him for careless. It says traveling at speeds in excess of 90, weaving in and out of traffic. Do you want to offer anything here?
Yeah, I'd like to offer 10 over.
Do you want to plead the 10 over, sir? That would be limited access 80 and a 70, and that would be 1 point.
Yes.
You want to plead to that?
Yes. Yes. Yeah.
To that charge of 80 and a 70, responsible or not responsible?
Responsible.
All right, I'm going to accept the plea. Fines and costs here are $155. You can go on 33court.com and pay that today, okay?
Okay.
Have a great day. Thank you.
Thank you. Thank you.
James Allen Kennedy. This is 6G 703768.
Morning, Judge. Jason Kazmarek for James Kennedy.
Good morning, Mr. Kazmarek. Your name, sir?
James Kennedy.
You got to get a lot closer to that device, please, and keep your voice up. I can hardly hear you. State your name again.
James Kennedy.
All right. So, counsel, does he stand mute and waive formal reading for purposes of the plea, of the arraignment?
Yes, Judge.
And now, as I understand it, you met with the prosecutor. Your client's going to plead guilty to operating while intoxicated, first offense, with the super drunk charge to be dismissed. True?
Sort of. I would actually I'd like to plead a no contest for my client.
Why a no contest plea?
Civil liability.
Was there an accident?
There was, and there was a couple injuries as well.
There was injuries to people in the other car?
And his own, yes.
All right. She didn't.
No, I didn't. Yeah, I don't know if we talked about it. We had talked about it over email or talked about it previously. But
the police report in here.
I can highlight some things on the police report. I don't know what your court requires as far as no contest, but I mean I can certainly provide the factual evidence.
Hang on. See.
Not Denali's office. Just gonna see.
Can you bring in the police report on James Allen Kennedy, please?
I will do that, Con.
Thank you. I don't care if there's possibility of civil litigation. I have no objection to that. I'm gonna have to get the police report in here. You heard me call.
From that night.
What's that?
So the memory from that night isn't great either, to be honest, Judge. He had a
Okay.
bit to drink.
Where's your office again, Mr. Kazmarek? I'm
Where
gonna
is
need
it?
the police report.
In Monroe.
Contest, please.
Oh, I can't do no, I wouldn't do non-contest for that.
He said that your appearance,
Good morning, Your Honor. To me, as remember, people be 893. Typically, we only run contests unless the redemption vote will be right. But is he saying he can't remember?
wait a minute, keep your voice up for the record here.
Oh,
No, he's saying there's a possibility of civil litigation. That's what his lawyer said, that there was an accident
as far as, yes, that's correct.
and that there were injuries to somebody in his car and or the other car. Both of them sounded like, right?
I believe so.
That's correct.
So why would you have a problem with that?
Typically, we don't do non-contest, but that's fine. We can get
The court rule forbids me to do it, so I can be the bad guy. So
said we need the police report.
I need the police report. If you don't have a paper copy, you're gonna have to send it to Lisa. I'm gonna go aside from this and I'll, okay, thanks. Lisa, I can send John down there when you get it, okay?
Okay.
Herman Elijah Morissette, 267-707-301, A and B. Sign an advice of rights form. Yes, you did. Okay, your name? Herman Morissette. So this gentleman, you met with the prosecutor, right? Yes. I arraigned you. You met with the prosecutor. She's offering you the opportunity to plead guilty to allowing an unlicensed driver to drive and the speeding 1 to 5 over, with the understanding that the no ops charge will be dismissed and the careless driving charge will be dismissed. Is that your understanding? Is that how you wish to proceed? Yeah. If you plead to 1 to 5 over, that's 1 point. But you're getting the 3-point violation dismissed. If you plead to allowing an unlicensed driver to drive, that's 0 points and it won't go on your record. And that is a 0-pointer punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? Yes. Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that? Yes, Your Honor. All right. You have the right to a lawyer. I told you that before. I'll tell you again. Do you want a lawyer? No. To the charge allowing an unlicensed driver to drive, how do you plead? Yes. To the charge 1 to 5 over, responsible or not responsible? Yes. I can't hear you. Yes. You plead responsible or not responsible? Were you in control of a 2008 Chevrolet silver in color that was being operated on June 9 to 26 at 6:53 p.m. On the ramp 226A near Sibley Road in Brownstown? Yes. Did you allow somebody to drive that was unlicensed or suspended or revoked, and was that you? Yes. And are you on probation or parole? Yes. Were you on probation or parole on June the 9 to 26? Probation or parole? To what court? On a felony? Yes. You understand by pleading guilty, I'm just telling you, this could be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this misdemeanor plea and conviction. Do you understand that? Yes. You still wish to plead guilty? Anybody in the world force you to plead guilty? No. Plea is accepted to allow an unlicensed driver to drive. I'm dismissing the no ops, accepting the plea to 1 to 5 over, dismissing the careless. I'm ready to sentence you. Are you ready? Anything you would like to tell me before I sentence you? You don't have a valid license. Wait till you get your license suspended. I've been going through a payment arrangement. I'm sorry? Payment. I've been going through the court payment arrangements. What courts? 36 districts. Anything else? 100 fine, 75 costs, 75 victims' rights, $50 justice assessment, 300 or 60 days. Do you have all that with you today?
Pardon, would you say that again?
$300 or 60 days, and I'm going to charge you $150 on the speeding. So you need $450. Do you have all that with you today?
Not right now. I'll do it in 60 days.
Where do you work?
G and F. I mean F and G. F and G's.
Can you pay anything today?
I just really started really last week, and it's a 2-week period. So the 60 days will be fine. It'll be actually partially up to so it's $450. I just started really last week.
I'm going to have you pay the $150 on the speeding by July the 24th. Can you do that?
Yes.
I'm going to have you pay the $300 on the other case by August 21st. Can you do that?
Yeah.
If you don't have the money, there's no reason to be scared. Just call the court. We can go on Zoom, or you can walk in, Your Honor, before the due date at 8:30, and I'll be glad to give you an extension. Fair enough?
Yes.
Good luck. Thank you.
Okay. Thank you.
Yeah.
Let me see what the ticket is written and find out.
Sure. Sadie. Do you have the police report on that one yet, on Kennedy, Lisa?
Yes, I'm printing it right now.
Okay. Hussein, I'm sorry, Mashu Hussein, 26B 711-738.
Good morning, Judge and staff. John Graziani on behalf of Mashoud Hussein, who's to my left. Please identify yourself, sir.
Mashoud Hussein.
Judge, I spoke with the prosecutor and we've agreed to adjourn for 3 weeks, but there's a separate issue. Apparently, Mr. Hussein would like to represent himself. I have no problem with that. He's not hurting my feelings. If he feels he could be better, I have no problem.
What law school did you go to?
Oh, it's college.
Yeah, I know, but what law school did you go to?
I think we're in law school, Your Honor.
You think you can do better than him?
It's not that I can do better than him. It's just that the case has been going on for so long.
It hasn't been going on that long. Listen. We started the case, you were arraigned on May 22nd. It's been going on for 5 weeks. Well, listen to me, sir. I want you to listen to me. You can represent yourself if you want. I don't know why you'd think you could do better if you went to Macomb County Community College. No disrespect intended whatsoever. It's more than some people do. This guy's been practicing law for 30 years, right? 35?
I can't believe it. 35, 36 years.
He's a good lawyer.
Thank you, Judge.
This is a serious case. You got a domestic violence charge. I'm just telling you, I'd urge you to reconsider. You have the right to represent yourself. You do. Everybody does. You could be charged with murder and you could still be allowed to represent yourself. It's just, I'm telling you, as a guy who's been around the block here, you're hurting yourself by representing yourself. You don't know anything about the rules of evidence, do you? You know what the rules of evidence are? I could take 10 days to explain those to you. There's all kinds of legal objections that you don't know anything about, sir. There's manners in which you can and can't ask questions. I'm just encouraging you not to get rid of your lawyer. I'll be glad to give you 2 weeks, but because the case is still pending, 5 weeks later means nothing to me.
It's just that
like, this was supposed to be my final pretrial, or there was supposed to be a pretrial, that's going to be last time I was in court. It was supposed to be a final pretrial, and it just, this time has been going on. And I don't have a place to live right now. I'm living off a hotel, I pay $500 a week.
Where at?
Days in the morning. I'm from Sterling Heights, and I don't live on this area. I have a home, and I lost my home. And while facing through these battles and tough times right now, in the process of going to court of my home that I'm living in, I'm about to be evicted. And I don't even live at that home. So in this case, that where it's the other victim is not here, it's not showing up. That's why I'm like,
who's the victim in this case, Mr. Graziani?
It's an ex-girlfriend.
Is she living in the house?
She was. She was living in the house. I suggested to him that he could move in, with permission from the court. However, it appears that everything's been shut off and it's basically a little, without any water, Judge. It's pretty bad from what I understand. But for the record, what Mr. Hussein.
Hang on one second. Can you staple this and mark this P? You're not helping by getting rid of your lawyer and representing yourself. Let me be blunt about it.
Understand.
So why don't I do this?
It's just that I think the judge speak. I'm trying to figure out what my final pretrial is, and I'm trying to understand that the victim isn't coming here.
Well, I can make him come.
Yeah, I understand that, but it's just that.
Call him Ms. Holloway again, John.
Good. I'm trying to understand that, like, this issue is, I'm trying to have it resolved. I'm trying to get back on my feet, go to work. I can't go to work. I don't have my car. I don't have a home. I don't have a place to live.
Have you guys conversed with the victim on this case involving Mr. Hussein?
Yes, Your Honor. As of yesterday, I believe I spoke to the defense. She's still cooperating.
That means she wants to proceed.
He wants to get rid of his lawyer. This makes no sense to me. Here's what I'm going to encourage you to do. I want the victim here at the next pretrial, okay? I'm ordering her to appear. I'm setting this for July the 14th. At what time, Lisa? 9:30 or something?
Yes, 9:30.
Just to clarify, are you ordering people to send out a subpoena?
Yeah, I don't care however you do it, whether you call her, tell her the judge wants her here on July the 14th at 9:30. But if she doesn't show up, I'm going to entertain a motion to dismiss. Now, I'm going to encourage you to keep your lawyer for the time being. You're not helping yourself by getting rid of your lawyer, okay? You're making it worse. Do you understand that? Now, if you want, since you seem to be in a hurry, if you want, I can set it for trial today too, for another day. I'll be glad to do that for you.
Is that a final pretrial?
Well, I'm going to have a final pretrial in 2 weeks, at which time the victim has to appear. And if she doesn't appear, I'm going to dismiss the case on motion of your lawyer. You can also set a trial, whether a jury or a bench trial, 4 weeks down the road or 3 weeks down the road. So if you guys want to entertain that, either a jury demand or a bench trial, but he wants to get rid of you, so maybe you don't want to make that decision.
Judge, I feel uncomfortable at this time.
Are you willing to keep your lawyer through the next pretrial?
Is that in 2 weeks, in July 14th?
Yes. I'm not going to be here next week, so I can't do it next week.
Yeah, that's fine.
If you want, I'll get rid of your lawyer. You're making a big mistake.
Yeah, that's fine. I would like to have presence.
You want him to?
Yeah.
July 14th, 9:30. We'll see everybody here then. Thank you. Charles Bejuan Boyd. Two 6W 706-997.
Good morning, Judge and staff. John Graziani, here on behalf of Charles Boyd. Judge, we had the opportunity to review the recent.
Your name, sir?
Charles Boyd.
Okay, Counsel, I'm sorry. Go ahead.
Judge, we had the opportunity to review recent report. There's no additions, deletions, or corrections. We are asking, however, that the no contact order be lifted. We have evidence that shows that his daughter contacted my client and
where's she at?
Currently?
Well, no, I'm asking, is she here, Lisa, Tahari Boyd?
Oh, not on Zoom.
Judge, she's not here. We do have evidence of text messages from her, which indicate that she wants to move back with Mr. Boyd. And
Well, I gotta have her here to tell me that. I can adjourn the sentencing a week or two and 2 weeks and have her.
Judge,
I can have probation call her. I mean, I'm not gonna look at text messages that she sent him without her being here and lifting a no contact provision, whether it's part of a bond or part of a sentence.
Judge, if I may, if we could possibly adjourn this matter simply for an hour. It was adjourned before. It was our understanding that parties would show up. Unfortunately, she hasn't shown up. I think transportation is an issue.
She can Zoom, but she can't. Let me do this. I constantly am looking for the prosecutor, and I can't remember what number she's into. Do you have any idea what number Ms. Holloway's in, counsel? I mean, Lisa. I believe I need to get a hold of Ms. Holloway. I'm going to have her call the victim and tell her I want her to Zoom in.
Thank you, Josh. Thank you so much.
She's in a breakout room. I'll try to move her out.
Okay.
I'm sorry for the interruption. May I have a breakout room too, please?
With Miss Louie?
Asmaro.
Or Miss Asmaro. Yeah, sorry. Hold on.
It's okay.
Yeah, I can't get her to move, Judge. I'm sorry.
Do you know what conference?
Oh, there she
room?
is. There she is.
Ms. Holloway, can you state your name on this, please? This is on Charles Boyd.
Hi, good morning.
Your name, please?
Nora Alloway on behalf of the people, PA 6528.
This is a sentencing on Charles Boyd. He pled to attempt DV. This involved his daughter, Tahari Boyd. I'm hoping the defense lawyer is asking me to lift the no contact provision. He wants me to look at text messages. I'm not going to do that, but I think in fairness, they want me to lift it saying she requested it and messages sent to the defendant. And I have a no contact. I'm going to ask that you or the victim's advocate call Ms. Boyd and ask her to Zoom in here at about half an hour or so. And then I can address it. Fair enough?
We can do that. Your Honor, just to clarify, this one isn't my case, but I will tell the victim advocate right now to speak to her, and Natanalia Asmaro can.
These days, I'm going to figure out who gets what here, you know?
That's okay. We'll handle it. Thank you.
Thank you very much. Thank you. You can have a seat, sir.
Thank you, Judge.
All right. Now, do you have that marked? All right. Recalling James Allen Kennedy, 26G703768. They came in with a big packet. I've had the whole thing marked. Counsel, your appearance.
Jason Kazmarek on behalf of James Kennedy. James Kennedy.
I'll be happy to take your no contest plea to operating while intoxicated first, with the understanding that the super drunk will be dismissed, and further with the understanding that there was an accident and apparently there's an allegation that some were injured as a result of the defendant's intoxication. So I'll go ahead and take that. Do you stipulate I can use the police report to establish a factual basis?
Yes, Your Honor.
Sir, a no contest plea has the same effect as a guilty plea. Do you understand that?
Yes.
You plead no contest to the charge of operating while intoxicated. The possible penalties are up to $500 fines, 93 days jail, 360 hours community service. Court costs are all of those 6 points, license, suspension, or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
I do.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or a trial by jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all your rights, including your right to a jury trial. And you're waiving the presumption of innocence and waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
I do, Your Honor.
All right. Now, a no contest plea, as I said, has the same effect as a guilty plea. You understand that?
I do.
I'm going to ask you how you wish to plead to the charge of operating while intoxicated, first offense.
Plead no contest.
All right, counsel, I've had the report. Mark, you said you stipulate to the admission of it for purposes of the plea, and I'm going to go ahead and take a look at it real quick.
Sure.
All right, based upon my review, I see. Based upon my review of the report, and there's a big stack here, I find there's a factual basis for the plea. Sir, are you on probation or parole?
No.
Anybody force you to plead no contest?
No.
Plea is accepted to no contest to that charge. I find the plea has been made voluntarily and understandingly and is an accurate plea. He's soon to be 25, correct, counsel?
Yes.
Has he had any criminal contacts other than this one? He had an MIP at 19.
A juvenile, I think, yeah, I don't remember anything else.
Couple, leaving the scene of a property damage. I want you to go into alcohol. Here's what I'm going to do. I'm going to say a personal bond, $1,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. And you are to attend AANA at least twice a week. You have to go in person. You have to go in person. And every time you go, you have to have the form signed. No contact with prosecution witnesses. When I say that, we can give you a form. You seek out my court officer. You're coming here for a screening and assessment. We're going to hand you an AA verification form. Every time you go, you have to have somebody there verify your attendance by signing it for you. AA twice a week in person, and you have to go to the Gibraltar Police Department, be fingerprinted and photographed today by 2 p.m. Do you understand that, sir?
Yes.
We're going to send over an order to them. So you'll come back here, you'll fill out a questionnaire, you'll be interviewed, and then you'll go over to the Gibraltar Police Department to be photographed and fingerprinted. And we'll set a sentencing date, AA twice a week, no contact with prosecution witnesses. Also, no alcohol, marijuana, or illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. What do you have for me as a sentencing, Lisa?
July 14th at 8:30.
Good with you, Mr. Gasmarek?
I'm sorry, July 14th at what time?
8:30.
Can we do the following week?
Yeah, the 21st.
That'd be great.
At 8:30. Okay. Any questions, Mr. Kasmarek or Mr. Kennedy?
No, Judge.
Thank you very much. Good luck, sir. Come on over to the courthouse. Thank you.
Thank you.
People against Sanchez Gomez and Edundo Andres Sanchez Gomez, 26M-690-991. What is this? Informal. Okay, where's Mr. Sanchez Gomez? Is he here? What's your name, sir? You have to unmute. Now you muted again. Tell me your name. Unmute. There you go. Tell me your name.
Me? Sorry.
Yeah.
I wasn't sure. Edmundo Andres Sanchez.
All right. Well, you're a winner today. The officer didn't show up. Case dismissed. It was scheduled for 10. It is now 10:36. You're all set. Just be, let me see here. Just slow down a little bit, okay? Good luck
I will
to
for
you.
sure. Thank you so much.
Thank you. Butler.
Bye-bye.
People against Butler. Damian Deshaun Butler, 260-706-769.
Good morning, Your Honor. Your great staff, Attorney Quentin Dox, plea number 79657. On behalf of my client, Mr. Butler. Mr. Butler, state your full name for the record.
Damian Deshaun Butler.
All right. I didn't even see this report, but apparently it came in. And all right. So, counsel, you stipulate we're going to have a competency hearing, and it says that you and the prosecutor stipulates the competency report. Unless you see a reason to, I'm going to just go ahead and have this marked. You stipulate I can use the police report to establish the competency here.
That's right. Yeah.
Not the police report. Forgive me. Jeez.
I know you.
I'm sorry. You stipulate to the admission of the competency report.
Yes, Your Honor. Yes, Your Honor.
All right, I've had that marked Peoples 1. So I've reviewed the report, and just give me 1 second here. Thank you. Court has reviewed the report and the findings of Margot Gilbert, licensed psychologist. The court finds the defendant competent to stand trial. Make sure that stays as a non-public record here. And then when are we going to do the exam? Can we do it on the 14th?
Yes, Your Honor. I believe if we could do 1 o'clock, that's fine.
You have an afternoon flat rock that day, Judge.
Can you not do it in the morning?
Your Honor, I'm jammed in the morning. I'm jammed in the morning in Third Circuit Court.
What about the 21st?
I can do it then, Your Honor. That's fine.
We'll do it the 21st at 10:45, okay? 21st at 10:45. We'll have the defendant read it out. All right, thank you very much. I'll see you guys here then. Thanks. This is definitely going, right, Mr. Dox?
Yes, it's definitely going.
Okay, we'll see you on that date. Thank you very much.
Thank you.
Thank you.
You have to come up with a date for me, Mr. Garrison. Lucas T. Bowman, 26M-709-278B. Your name?
Good morning again. For the record, Trevor Garrison for Mr. Bowman.
You guys couldn't resolve this?
I tried, Your Honor. I've tried. I mean, we got dash cam video. It's going under 70. I don't know.
Well, going under 70?
He's going under 70, according to the dash cam.
All right, July 28th. What time are we doing?
Great. Yeah, I was going to suggest that, but would it please be all right if I get there around 10:45, 11?
Yeah, 10:45, July 28th at 10:45, formal hearing. Okay?
Thank you so much.
All right, have a good day. Thanks.
Well, one last question. I'm so sorry. Some judges go either way. Do you want my client there in a civil infraction? He lives in Ohio.
Yeah, he's gonna, we're having a formal hearing. Yep,
right,
he's
thank
gonna
you.
have to be here. Okay?
Yep.
Thanks. Wilkins, Alexander the third, 26M 665 269 A and B. Is this yours, Mr.? He left. All right. I'm gonna have to wait for him. Good morning, counsel.
Good morning, Judge.
Can you go get him, see if he can see Mr. Graziani out there, please? All right.
What's that? He's right now, but fine. I don't know. Still, yeah. So you want to look on Scooter? Yeah. I just wanted to Lisa first. I was having a meeting.
All right, people against Wilkins, Alexander the third, 26M 665 269 A and B. Good morning, Mr. Graziani.
Good morning, Judge and staff. John Graziani, Attorney behalf. Wilkins Alexander, who's on my left.
Your name, sir?
Wilkins Alexander the third.
All right, so he's going to plead guilty to the charge. Consider dismissing count 2. To no license, correct?
To no ops, yes.
To no ops or to no license? He does have a valid license, does?
Judge, what's happened is he's been trying to get the license because of logistical concerns. It just
He's got a valid license, it says.
he does not have a valid license. Is that correct, sir?
Why does it say valid on here?
Judge, what happened is he attempted to get a license. He had difficulty in one of the prerequisites in the course, did not pass that course all the way successfully, 90% of the other things. And because of the schedule that you have, it's necessary that we are at this time.
All right, so you're gonna plead to no ops, correct? Yes. And they're gonna dismiss count 2. If you plead to no ops, possible penalties are up to 100 fines, 90 days jail. Costs are all those. Do you understand that?
Judge, in this situation, I'm asking for mercy because this gentleman has attempted to work very hard to get his license and it just.
I'm just taking the plea as charged, though. This is more than no ops, right? He did not have a valid license, correct?
That is correct, sir.
So if you plead guilty to this charge, the possible penalties on this are up to 500 fines, 90 days jail, costs are all those, right? You understand that? And then I'll dismiss the civil infraction of using a handheld device. Do you understand that? If you plead guilty, you're giving up all the rights on the advice of rights form. Do you understand that? You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. At a trial, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. Do you understand? All right. If you plead guilty, we're not going to have a trial of any kind. Do you understand that? To the charge, keep your voice up. No license. How do you plead? Were you operating a motor vehicle March 6th of 26 on Telegraph near Dix at Brownstown at 10:55 in the morning?
Yes,
Did you have a valid license at that time?
No, I did not.
Are you on probation or parole?
No, I am.
Anybody in this world force you to plead guilty?
No.
Plea is accepted. Count 2 is dismissed with prohibited use of the handheld device. All right, I'll sentence him. What do you have to say?
Judge, basically, that this gentleman's attempted everything possible because of time constraints and money constraints. But it's mostly that one incident that took place when he was taking a course. And so as a result of it, I hope you have some mercy.
What?
He attempted to take a course, Judge, and he was unsuccessful in completing a course. There was one part of the course that he was unsuccessful in. That's why we're here, sir.
You gonna go back and try it again?
Yeah.
Anything you want to tell me?
Go ahead, sir.
I'm going to continue to do it. I'm trying to get my license. That's what I want.
And the course that I'm taking, you know, I'm paying, I don't have money really to pay.
Where do you work at?
I work in Myers warehouse in Newport.
What do you make? About 21 bucks? How much?
$15 an hour.
He's got a pay mortgage.
That's a base pay. And they go by the trucks you unload.
How old are you?
I'm 58.
100 fines, 60 costs, 75 victims' rights, $50 justice assessment, 285 for 60 days. You get paid weekly?
Yes.
I'll let you pay $35 a week. I'll start that beginning on July 16th. Can you do that?
Thank you.
All right, let me just double check. July 17th. Now, listen, if you don't have the money, don't be scared. Just call the court or come talk to me on or before the due date. On or before the due date, 8:30. I'll be glad to give some extension, okay? I wish you well. Good luck.
Thanks very much.
Thanks a lot. Good luck.
Judge, I was just waiting for Mr. Boyd. We'll get it in a few minutes.
Well, do I have the victim here?
Apparently she's on, but Mr. Boyd stepped out. We thought it'd be like.
Fine, I need to take a recess anyway.
Okay, thank you.
So does my incredibly hardworking staff, especially my court office.
It's true. Let me. Go back. So.
Do I have Tepe here somewhere? You know?
Each one?
Tepe Boyd.
We're here for Boyd, but it appears she's in the breakout room, Judge. That's what.
Okay.
Or the advocate. What are you reading now?
What's your name, ma'am? Yeah.
Segura, Attorney Segura.
Sure. Okay. Sorry. Rayona Lajuan Jean Golden, 26B 713-794 FY.
Good morning. This is Segura with the Neighborhood Defender Service, 86432, appearing on behalf of Ms. Golden, who is present via Zoom. Ms. Golden, will you unmute your device, turn your camera on, and state your name for the record?
Rihanna Golden.
You look like you're in a. Yeah, you got to turn some lights on.
Sorry, I was waiting for the thing.
All right, you're fine there. All right. You're asking to withdraw. You say you got a conflict.
I do. I previously represented someone that is listed as a witness on the prosecutor's witness list and is named in the discovery. So I do believe that if this were to go to trial, I'd have to cross-examine a previous client of mine, and I just think that that is a conflict under the professional.
I'll go ahead and grant your motion to withdraw. We're going to appoint a new lawyer, or is somebody from NDS going to be here?
No, Judge. So unfortunately, NDS rule is that one has to withdraw.
Adjourn. Lisa, can we call over there and try to schedule the PCC for next week?
Yeah, I can have somebody here next week.
And then July 14th preliminary exam, okay?
Thank you, Judge.
So we'll make the PCC at what time? At 10 on July 7th, and then July 14th at 11 preliminary exam, okay? Do you have an order for me to sign?
I did not prepare an order, but I can submit that to your court if you would like.
Would you do that? They can give you a form order down there if you want to fill it out and bring it back, and I'll sign it. It'll be done, okay?
Sounds good, Judge. I will do that.
Thank you.
Thank you.
All right, so you're saying that we'll see you next week, Ms. Golden. I'm granting your lawyer's motion to withdraw. So we'll see you July 7th at 10.
Come in person July 7th or come back in Zoom?
You can come back on Zoom next Tuesday at 10.
Okay, thank you.
All right, thanks.
And Judge, where do I get that form from?
They'll give it to you right down in the clerk's office at the end of the hall. Thank you. Is Ms. Boyd on? I was told she's in a breakout room.
She should, yeah, I gave her the Zoom information, Your Honor, so she should be on there.
She has not logged on.
Let me call her real quick then.
Okay, thank you. I can't.
No, okay, that's
I
fine.
mean, usually we do the pre-trials and the probable cause conferences.
No, it's 11 o'clock works fine, Judge. I
Okay.
just wanted to,
Well, I'll tell you what, let's make it 10:30. Is that what you want? I can do that. We'll do it at 10:30, July 21. That'll help with it, I guess. Okay?
okay.
All right. And I've signed your order so you can take the file and they'll give you a copy, true copy of it.
Thank you very much, Judge.
Have a good day.
You want me to take the file up front?
Yeah, sure. You can do that. John, hand him the file, will you? Or Sadie. Do we have Ms. Boyd on yet?
She's supposed to be logging on, Your Honor.
Okay, thanks. Good luck, sir. Go down the hall, get your new notice, okay? Thank you. Oh, boy. John. What are you? As always, is this she on this case?
Do you need this background because it's probably daughter? Do we need Miss Asmero?
Just tell her the victim's here. If she has something to say, she can come in, okay? People against Charles Bajuan Boyd, 26W706997.
Good morning, Judge and staff. John Graziani, appearing on behalf of Charlotte Boyd. This is
Sir, your name?
Charlotte.
Ma'am, I need you to start your video now. You were on there a second ago, and I need to see your face.
Yeah, hello.
Okay, I need to see your face, not the top of your head.
Okay.
All right. What is your name?
Tihari Boyd.
Can I see your face? Not the,
Yeah.
There you go. There you go. How old are you?
17.
All right. Counsel, your client pled to attempted domestic violence. He was referred for a report, pre-sentence report. Have you reviewed the report, and are there any material additions, corrections, or deletions?
None, Judge. The only thing that I have is I'd like, because of his schedule, he'll be working some overtime at Ford. I'd like you to combine the work program with some community services and make it as feasible as possible.
Anything you'd like to say, sir?
Just whole situation shouldn't be here. Put myself here. You know, it's just really want to get forward and get my daughter back on the right track. She's missed 58 days of school.
He feels a tremendous amount of guilt.
Yeah, because we so crazy.
You're not missing school, are you, Tari?
Yeah, I did miss school because I had to move with my mom and she's all the way in Westland.
Okay, keep your voice up nice and loud. I'm getting old. I need to hear you.
Oh, can you hear me now?
Yeah, you got to keep your voice up nice and loud. Yeah, you missed school.
Yeah, I missed school because I had to move in with my mom and she's all the way in Westland and she can't keep making that drive. And she tried to transfer me to online for that school, but my dad didn't sign the paper, so I couldn't do online.
Do you want to have contact with your father again?
Yes, I do.
Look at me. I need to see your face, young lady. I need to see your face. The reason I had you called is because his lawyer said that you sent texts to your father saying that you wanted to be able to talk to him and see him and that type of thing again. Is that true or is that false?
Yeah, it's true.
You want to have contact with him?
Yeah.
You got to go to school. You know that, right?
Yeah, I do.
This happened back in March. How are you doing in school prior to March? How were you doing, I should say?
No, I wasn't doing in school. I was doing online.
You were online for school prior to the date of the incident?
No. I was doing in person.
I need to see your face. I can't hear you. You've got to listen to me. The incident happened March 27 to 26.
Yeah.
How are you attending school in January, February, December, November, October, September? How were you going to school?
I rode the bus to school.
Okay, so you went, look at me, you went to school, right?
Yeah.
In Woodhaven, right?
Yeah.
What school were you going to?
Woodhaven High School.
How were you doing with your grades?
I was doing decent.
What's decent?
Like A's, C's, B's.
That's not decent. These aren't good. What was your grade point average? Do you know?
No.
If you don't know your grade point average, you're probably not taking it very seriously. Listen to me. You're not going to make anything of yourself if you don't graduate from high school. You got no chance. Understand what I'm saying?
Yeah, I understand.
You got a better chance of throwing a wiffle ball into 122-mile-an-hour wind than you do making it in life if you don't graduate high school. Do you understand what I'm saying to you?
Yes, I understand.
That means you're going to be in poverty. You know what I mean by poverty, right?
Yes.
Nobody wants you to be in poverty. Okay?
Okay.
You got to work at this a little bit. Nobody gives us anything. Your father's got a good job. He works hard. They didn't just give it to him. And he wouldn't have it if he didn't graduate from high school. Now, I got to tell you something. I'm appalled by what your dad did, but you weren't exactly respectful with him either. That gives him, that is not an excuse for what he did. Smacking you is not an excuse for what he did. I want to be abundantly clear about that. Do you understand what I just said?
Yes, I understand.
I want to read you something. And I want to know as you used the F word and called him bro.
Yeah.
He's not your bro. He's not your friend. He is your father, and you have no reason to use the F-bomb with him. You got it?
Understand.
You understand what I'm saying? You got to show respect.
Yeah, I understand.
You shouldn't have let it go this far. You should have never hit it though.
I agree.
But we got a problem here because your dad and your mom both want you to succeed. You cannot possibly succeed if you're not going to school. No way, no how. I don't care how smart you are. I don't care if you got 159 IQ. I don't care. You cannot succeed in this world if you don't go to school. Do we understand that?
Yes, I understand.
If we don't go to school, we do not graduate, and then we live in poverty for the rest of our lives. We do not want that for anybody. Do we understand that?
Yes, I understand.
And you need to be more respectful to your father, even though, as I said, there's nothing that justifies that conduct of his. Do we understand that you need to be more respectful?
Yes, I understand.
We understand that you need to respect authority.
Yes.
All of us have rules to comply with. I have rules. We all have rules. Now, you're sure you want to have contact with your father?
Yes, I'm positive.
12 months probation. We're going to release the bond conditions. Here are the new conditions. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed at the probation department. And if you change your address, place of employment, or home telephone number, you must notify probation. There's to be no assaultive, abusive, or intimidating behavior, Mr. Boyd, toward your daughter, Tahari Boyd. You're not to possess firearms. You're not to possess dangerous weapons. You're to attend the domestic violence program with 8-week follow-up. I want you to do 3 days on the court work program. There's a $105 charge for that. Fines $100, costs $100, 75 victims' rights, $50 justice assessment. So your fines and costs are $3 1/4, screening fee $60 for $385, probation fees are $240 for $625, $730 is your total with the court work program fees. This was a plea to an attempt. So if you violate, you could get 45 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that? Yes? Yeah. I'm going to ask you, can you pay all these fines today?
That's it.
When can you, how much do you have to?
I won't get paid until Friday.
How much can you pay Friday?
Give you $200.
All right, $200 by, we're not open Friday, by July the 6th. You get paid weekly?
Yes.
Then $50 per week thereafter. Then $50 per week beginning July the 30th. I'm sorry, July the 13th. We understand that?
Yeah.
If you don't have the money, it's not a problem. You can either come into the courthouse on or before the due date at 8:30 or call the court and we'll go on Zoom. Young lady, I hope our little conversation is going to make you understand, though, that you have to do better for yourself, right? At the end of the day, we're responsible for our own selves. And maybe your father was wrong by yelling at you. And I read the report. I get it. You couldn't hear him in the shower. You said, I get that. But we don't not go to school. We cannot fail to go to school. We do not want to be living in a car like I see every day almost, or living in a hotel, or going room to room, house to house in different places because we can't afford to pay for our own apartment, house, whatever the case may be. So we understand, right, Tahari? You're gonna try to do better, right? You're gonna be more respectful and you're gonna try a lot harder in school, right?
Yes.
I can tell by talking to you, you're an intelligent lady. These are unacceptable. These are unacceptable. So you got to study. We got to work, right?
Yeah.
All right. I wish you guys well in mending your relationship. I really do. This is tragic. I hate to see father, son, mother, daughter. I hate to see any of this. Father, daughter, father, whatever.
Judge, thank you so much for
Have a good day. Thank you.
Thanks for keeping the front of the court out of this.
You're going to go meet with probation, okay? Right across the hall there.
Oh.
I don't have any other files here. Did you talk to the prosecutor, Ms. Tucker? You've been here a long time, it seems like.
Yes, I have, Your Honor.
What's going on with you? You've been on there for an hour and a half and I don't have a file.
Christopher Walls. I was assigned this morning.
Okay. Did you talk to the prosecutor?
I did. We're gonna do a week's adjournment and an exam after that.
Okay. Do you have Mr. Walls's file? You do?
Mr.
How
Walls
about-
is no longer in the breakout room also.
How about Mr.
Spoken to him this morning too.
How about Mr. Bulahanis's file? Did he talk to? Who's his defendant? Who's your defendant, Mr.
Yep.
Bulahanis?
Your Honor, my defendant is Nicholas Sakala, and I'm sorry.
No, I was just trying to get your file so I can get you out of here.
I haven't talked to, she hasn't been there for as long as I've been in the breakout.
Oh, who are you trying to talk to, Ms. Esmar?
Yeah, but may I say something real quickly, Your Honor?
Sure.
We haven't received, we requested the discovery. We haven't
Well,
received.
we're going to cover that when she's in here. Where, can you set up her in the breakout room with Mr. Bulahanis, please?
Yeah, I had him in there. I've already had both of them in the breakout room with her.
I went into the main session, Lisa. I'm sorry. Can you
That's
put me
okay. I'll
back
move you
there?
back. Yeah.
Thanks.
I need Mr. Walls back. But he disappeared.
Yeah, he's been here all morning and then now he's gone.
Nice. You want to call him, Ms. Tucker, and tell him to get on here? I mean,
Yep, I will give him a call. He gave me his number.
How many works?
I don't know how many they were sitting on. Graziani's got
2863, the state of Ohio versus Austin Deaton. Mr. Deaton, the court has received a report that alleges you have violated the terms of your ILC supervision. Would you read that for me, please?
Yes, Your Honor. The defendant did violate ILC condition number 5, in which the defendant failed to comply with the terms and conditions of his electronically monitored house arrest on various dates between May 22nd of 2026 to June 21st of 2026, as well as ILC condition number 7, in which on June 26th, 2026, the defendant submitted to a drug screen positive for marijuana, admitted to use of the substance.
All right, Mr. Deaton, do you understand those allegations?
Yes, Your Honor.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you. Do you have the funds to hire an attorney?
No.
Do you want me to appoint you one?
Yes, please.
All right. This is an affidavit of indigency that you need to sign for me, please. Court will find that you are indigent for the purposes of retaining counsel, and I will appoint Attorney Ben Swift to represent you in this matter. Court does find that there is probable cause you have violated the terms of your supervision. You will be held in the Warren County Jail pending that final hearing. Okay, thank you.
1.
We're ready, Your Honor, to be
What's that?
for the exam, Mr. Daniel Gomez.
I'm ready. Absolutely.
I was ready for you. No problem. Want me to do them all in here?
Sure.
Awesome.
Nicholas John Sakala, 26S535-6488.
Good morning, Your Honor. Greg Bulahanis on behalf of Nick Sakala. Your Honor, he just went to his vehicle because I asked him, I had him doing AA attendance meetings and I told him I'd have, even though he hasn't been ordered, I want to see him before I make any representation to you. Here he is right now. And this occurred on 5/30/2026, Your Honor.
All right, Mr. Sakala, your name?
Nicholas John Sakala.
You got to get a lot louder than that. What?
Nicholas John Sakala.
All right, Mr. Bulahanis, your appearance again?
Greg Bulahanis, P36431, on behalf of Nicholas Sakala, Your Honor.
Does he have any priors?
2012, he has a impaired.
Driving?
This is a operating a boat while intoxicated.
Does he stand mute, wait formal reading for purposes
Yes, Your
of
Honor.
arraignment?
Yep.
Not guilty, please. Well, not guilty, please entered. Were you printed and photographed that night, sir?
Yes.
All right. $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I want you going to AANA at least one time a week. Again, no alcohol, no marijuana, no illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer. So I'm going to ask you to hand him I want him to go at least once a week going forward. Okay, we'll give you a pretrial date.
Your Honor, may I address the bond just briefly? He does a lot of work out of state. His next employment that takes him out of state is July 15th to 21st in Kentucky. He's going to Kentucky. He does go out of work at least once out of state at least once a month for employment purposes anyway. For employment purposes, Your Honor. So could we modify the bond to accept employment purposes?
I will do that. No, so he can leave the state for employment purposes, and specifically can also leave between July 15 and July 21. We can give him a pretrial date on the 14th. How's that?
One moment, Your Honor. I did want to indicate, I did see his AA attendance sheet, Your Honor, and he's attended 6 meetings already since June 14th.
Okay.
And they're in person.
Okay, good.
One moment.
July 14th at 9:30 we gonna do?
1 second. I'm pretty booked on July 14th, Your Honor. I have 3 hearings in the morning. And couple of them are in person.
I'll do July 21st at 9:30, and your client can appear by Zoom. How's that?
Can we possibly make it at 8:30 because I have an implied consent at 10?
8:30, but your client has to be pulled over, okay, if he's driving. July 21 at 8:30, so you can leave the state, sir, and you can appear by Zoom, all right? Good luck.
Thank you so much, Your Honor. I just got the discovery this morning. We're still waiting for video, just so the court's, advise of that.
Good enough. Thank you.
Thank you, Your Honor. You and your staff have a great day.
You too. Chadwick Francois Walls, 26F714814. Ms. Tucker, your name?
Tamika Tucker, PA 5402, on behalf of Chadwick Walls.
Did you get a hold of him? Where is he?
Your Honor, I do not know. I was assigned this morning, but I did speak to him in the breakout room. I did get a phone number from him. I have called him 6 times since we've been waiting and left numerous voicemail messages with the Zoom. and I am not getting a response.
I don't know what happened, but he was here a long time. I'll tell you what, I'm going to adjourn the PCC. I'm going to set a PCC for July the 7th. So you have to get a hold of him. What time can we do that, Lyndon or Lisa? Then July 14th exam.
9:45.
July 7th at 9:45, July 14th at 10:45. Is that good?
That's great. Oh, sorry.
No, you just have a lot that day. You want to do like 11:15?
Sure. We'll do that.
That's even better.
We'll do that at 11:15, okay?
Thank you, Your Honor.
But 9:45 next week. So make sure you get a hold of him and tell him if he doesn't show up, he's gonna have a warrant issued, all right?
I sure will.
Thank you.
Judge, those 3 tickets that were set on that 8:45 time, only showed up on them, so I don't know on them. I think that's it though, other than the PM and
Are they just department rep or what are they?
AAA Logistics and FBI Express,
Let me see them.
all set for 8:45.
There's no attorneys on those, Judge.
See here. All right. AAA Logistics Inc., 26S118463. Defendant is responsible, is charged by default. This is a corporation. So send them a notice, Lisa. And then if they don't pay, we'll show cause the president. MBI Express, 26S118469A. We're going to go ahead and find defendant responsible is charged by default. Same thing. If defendant doesn't pay, we will go ahead and issue a show cause against the president. And also I have MBI Express 26S118469B. Same thing. That's just an overheight charge. And they're going to have to understand they're going to be taking care of that. Or we're going to be show causing the president. Thank you. Daniel Antonio Gomez, 26I712442. Good morning, everybody.
Good morning. Good morning, Your Honor. Mount Leah, about P58 930.
And James Mikowski, P6215, Green Gamma Post Mass, Danby Pirate.
Good morning.
And sir, can you state your name for the record? Daniel Gomez.
Okay, today's the date scheduled for preliminary examination. You can be seated, Mr. Gomez. We have, let's see here. 2 counts anyway. 3 counts. Assault with a dangerous weapon, a 4-year, felony firearm, a 2-year. There will be no exam on reckless use of a firearm as set forth in count 3, since that's a misdemeanor. So any preliminary matters, Mrs. Morrow?
One preliminary matter, the OIC is standing to my right, Detective full name Constantine, and just Frank Harris, he did let me know that, and this appointment.
I can't hear you.
He did let me know that, and he has an appointment to get to, so if he could be excused, for the closer stop time, so he can go to his appointment.
Any objection?
No objection. I don't think we'll be that long, Judge.
Okay, you can go ahead. Whenever you, what's your appointment? You need to leave now?
No, I got time.
Okay, so yeah, if you need to leave, you leave. Any other preliminary matters? Mr. Mikowski, any from you?
No, you're.
Call your first witness.
Stephen Jocelyn.
Come on right up here, sir, to the witness stand. Raise your right hand. You solemnly swear affirmative penalties of perjury that the testimony you will give of these proceedings will be the whole truth, so help you God.
Yes, sir.
Okay, you have a seat. And you may proceed, Ms. Ismail.
Thank you, Your Honor, and good morning, Mr. Jocelyn. Mr. Jocelyn, could you please spell your first and last name?
STEPHEN. Last name Jocelyn, JOS1N.
Thank you. And Mr. Jocelyn, I want to take you back to May 27, 2026. Do you remember that day?
Yes, I do.
And on that day, were you at or near Cellar and Raven?
I'm sorry, Silver Island? Yes, go ahead.
Then the township of Roseal,
Yes,
County of Lane.
yes.
And on that day, were you there earlier in the day or later in the day?
So it was like an afternoon thing. Okay.
Was it still bright out or dark?
Oh, it was right out.
Okay, who were you with that day?
So I was with Ashley and our children, or our girls.
Okay, how many kids do you have?
So I have one daughter, or two kids, but my daughter was there that day, and then Ashley has two daughters. So
Okay,
we're talking about 3 little girls.
okay, and what were you guys doing on Cellar Island?
So the girls like to play at the beach. There's a swing. They like to play in the sand. We were just hanging out.
Okay, were you guys on foot at the beach the whole time? Were you guys on any,
For the most part, yeah.
what do you mean for the most part?
Well, you go to the beach to walk down and play in the sand. So, yeah.
Okay, do you guys have a boat?
Yes.
Were you on the boat as well?
Not me specifically. No, I was mostly on foot.
Okay. And, but did you have a boat at that location that day?
Yes, I was actually parked on the beach right next to Daniel.
Okay, you stayed at Daniel. Who's Daniel?
Would be sitting right across from me, right there. You know, go with.
Could you tell us what he's wearing?
So it's like we are not a white long sleeve button up today.
And your records kind of the record what I said I didn't, Mr. Gomez.
Record should show reflect.
Thank you. And how is it, Mr. Gomez?
So Mr. Gomez shows up to the beach a lot. That's how I know Mr. Gomez.
Okay, and did something happen between you and Mr. Gomez on May 27, 2026 that brings you into court today?
Yes.
What happened that brings you here?
So on that specific day, I got pistol whipped across my face.
Okay, let's go a little bit before that. Was there an altercation that occurred before that with Mr. Gomez?
There was an altercation between Mr. Gomez and Ashley.
Okay, who was Ashley to you?
So Ashley's a girlfriend.
Okay, and then did you witness this altercation?
I was not aware of it until Ashley told me.
Okay, so you were provided information by Ashley,
Correct.
and based on that information, what did you do?
I asked Mr. Gomez why he's trying to start an altercation between me and Ashley.
And where were you and Mr. Gomez?
So I was standing in between the boats.
And does Mr. Gomez?
The water, I was standing in the water next to my boat.
Okay, and then did Mr. Gomez have a boat?
Yes,
And where was his boat in relation to yours?
he was parked right next to me.
Okay, and then you say you were standing in between boats?
Correct, well, in the water next to mine.
Okay, and where was Mr. Gomez?
At that specific time, he was on his boat.
Okay, and then you stated earlier that you asked him, what did you ask him?
I asked him why he was trying to start an altercation between me and Ashley.
Okay, and what happened after that?
So at this point, Daniel was already on his boat. But that's when he pulled out his pistol and lets 2, maybe 3 rounds go, and then reaches over the side of the boat and pistol whips me with what I believe is a 9mm Glock. All action.
And did you see where Mr. Gomez pulled his gun from?
What was the question?
Did you see where he got the gun from? Was it on a chair? Was it in?
It was underneath the steering wheel of his boat.
Okay, could you describe it? Did you recall what it looks like?
It was black. I don't know. It looked real similar to a 9mm Glock of what police officers carry on their head.
Okay, and then you stated, did Mr. Gomez say anything to you?
So Mr. Gomez kept talking, yelling at Ashley.
And where was Ashley?
So Ashley was on the boat recording everything that happened.
And at what point did she start recording?
If you know.
Oh, so she's,
So, this might possibly be watching if we could just take care of that real quick, because they're not supposed to be.
We're watching where?
Okay, I apologize. So you
can you repeat
stated,
the question?
where was Ashley?
Well, no, you asked when did Ashley start recording, if you know?
So Ashley started recording when I told her to, and that was immediately after he had let 2 rounds off in pistol with me.
So none of that was on the record.
So the recording starts immediately after.
Okay.
Okay,
Immediately after, because I looked right at her and said, start recording.
okay, so she's on your boat?
She's standing on my boat, on the phone with the Grozio Police Department as she's recording. Both at the same time.
And do you recall, where was this firearm pointed? Where was it being pointed when it was let out or let off?
So it was being pointed towards the beach.
Who was on the beach, if anybody?
So there were the 3 little girls, and then 2 of his other passengers were all running on the beach. So they were already on the beach.
Okay, and how many did you hear go off?
2, potentially 3. Before he reached over the side of his boat, pistol at me.
Okay, and then what side of your face, or where were you pistol with?
On the left side of my face.
And how many times?
Right on the temple.
Okay, and how many times were you pistol with?
1 time.
And was there any injuries or water stop because of this?
Yeah, I mean, it's swelled up. It swelled up. It hurt to open my jaw for a little bit, but that was it.
Okay, and would you recognize the injury you saw today?
Yeah,
Judge Oda? Judge, make sure my screen, I had one on.
You may.
Let me just do the breakout. And Mr. Johnson, if you could just turn around. And people's proposed exhibit number 1, do you recognize what's been put on the screen?
Yeah, so that was right after it happened. We were actually still at the beach for that picture.
Okay, and is this the injury that you're referring to on your temple?
Yes.
On the side?
Yes.
Does it appear to be an accurate depiction of the injury that you got in this incident?
Yes.
And does it appear to be changed, altered, manipulated in any sort of way?
No, not at all.
I will be moving to the people's proposal.
Any objection? No objection. People's one is admitted.
Thank you, Your Honor. And I'm gonna stop sharing my screen. Okay, when this occurred, did you have any weapons?
No, ma'am.
Okay. And did you seek any medical attention?
So when I got examined at the Metro Parks, when the ambulance came, they asked me a few questions on if I had felt dizzy or blurriness of vision, and I had answered no to those. So that was their main concern, that and a concussion. There was no signs of that.
Okay, and were the police called?
Yes.
And did they arrive?
Oh, yeah, yes, they were there at the dock waiting for me.
Okay, and then did you speak to the police?
Yes,
Did you let them know what happened?
it was the officer, one of the first ones at the dock.
Okay, and, nothing, bro.
Cross?
Oh, yes. Oh, yes. So, Mr. Jonathan, you've known my client for quite a number of years, haven't you?
Yes, I have.
Because you stayed his girlfriend, correct?
He's technically dating my ex-girlfriend.
So to say that you hang out at the beach with them, that's kind of a misrepresentation of that relationship, isn't it?
So Mr. Gomez has been going to the beach for many years, just like many other people.
Okay, but you've known each other outside of that because he dated your girlfriend, or you stayed.
No, I only see him and out at the beach. We don't hang out.
Okay.
I don't call him to go get dinner or.
Okay. And you're aware that my client's a 100% disabled military vet, right?
Yes.
Okay. And is it true my client fired one shot?
From what I recall, it was 2, possibly 3.
How much did you have drink that day, sir?
I think I was drinking water that night.
You were not consuming alcohol.
No, I had my children with me.
So you're claiming that my client was starting something with your current girlfriend?
Yes.
And
well, he had his passenger come say something to my girlfriend. He couldn't do it himself.
And you just called and said, please stop doing that?
Well, I asked him why. I asked him if he thought he was going to tell her something she didn't know.
Is it true you were very belligerent?
No, because unless water gets you belligerent, like.
Okay. All right. So you claim my client fired 1, maybe 2 rounds, 2, 3 maybe rounds.
Maybe that's what I heard before I got pistol whipped.
Okay. After you were supposedly pistol whipped, what did you do?
I told my girlfriend to start recording so that Danielle could make the news.
And did she record you assaulting my client's passenger in his boat?
No.
And did she record you?
She was.
I'm sorry, I'm asking you a question.
Okay.
Okay, guys. Wait.
It's like you're telling me.
Wait a second. You can't talk over him.
What do you say?
Do you understand what I'm telling you? Listen to me very carefully, please.
Yes.
He's going to ask questions. You're going to supply the answers.
Sure.
If you don't know the answer, you tell him. If you don't remember, you tell him. Okay, so let's back up.
Yeah.
But when
question?
hang on a second. When I start talking, even if you are, you stop. You understand what I'm telling you?
All right.
All right. Repeat your last question.
Isn't it true that your girlfriend recorded you assaulting the passenger in the boat?
Object to that question, him assaulting a passenger.
Give me the time frame. Was this before or after the incident?
I'm saying what was recorded after the incident. Did you review the recording?
Wait a minute. Wait. Don't just start asking the same question.
That's fine.
Wait a minute. Guys, listen to me. I'm going to tell you what you guys can ask and what you can answer.
Okay.
Okay? I'm going to allow that one question. Was there any indication that you were assaulting the passenger in Mr. Gomez's boat on the video that was taken by your girlfriend? Yes or no?
No.
Ask your next question.
The video that your girlfriend took, it was supposedly after the shots were fired, right?
It was immediately after.
So it was after. Okay. And after these alleged shots were fired, you kept approaching Mr. Gomez's boat. Is that correct?
No. I was standing in between our boats. I was already there. He had a pistol with me. He reached over the side of his boat, pistol with me. So I was already standing right next to my boat, which was in between the two boats.
Did you back up? Did you leave?
I took his anchor, set it on his boat and pushed him off because he had a pistol.
So you were so scared and you didn't retreat, but you kept talking to him and then you went over and
After I realized-
I'm sorry, I'm asking you.
Wait a second. That was multiple questions inside of that. That was a compound question that was going to fourth base. And you don't have the right to interrupt him, sir. Please listen to me. I want you to look at me now. He might be asking questions you don't like or don't want to answer. Don't interrupt him. You show some respect to the witness too. And we're going to start with that question again, and you're going to.
I feel like he's not asking a single question.
Sir, if there's an objection to be made, the prosecutor is going to object.
Okay.
Okay? Now I'll rule on it. You're not the judge in here. You're not the prosecutor in here. You're not the lawyers in here.
Okay.
Just let him finish the question and answer unless I tell you you're not to. Do you understand?
Yes, sir.
Now, let's make it a more simple question rather than going into hypotheticals with 3 or 4 questions inside of one. Go ahead.
So after these shots were allegedly fired, you didn't retreat, did you? It's a yes or no question.
No, because I was standing next to my boat.
So you didn't retreat.
I was
Okay,
already there.
all right. So you didn't back off. Is it true, Mike?
Wait a minute, did
That's
you
not a
answer?
question. I'll try that question. How many times did my client ask you to back away from him
Never,
prior to discharging the fire?
never. I kept hearing Lauren Winston is what I remember hearing before I got pistol whipped.
He never warned you. No. Okay. Your girlfriend starts recording the incident, right?
We've covered this. Wait a minute, slow down. We've covered this. Almost immediately after the gentleman, according to his testimony, your client fired 2 or 3 shots and then pistol whipped him. He told his girlfriend to start recording and she did.
I was going back to give him context somewhere. My next question was going to Judge, but I apologize. I'll cut to the chase. So after you didn't retreat.
He said that.
You took his anchor up and unanchored him and pushed him into the water, right?
Correct.
You can step down. Call your next witness. Move the bind over.
Yes.
You agree it's a fact question?
Your Honor, I just want to make a statement here. If we're to believe that the complaining witness story, then he had multiple shots fired, like, whether it's 1 or 3, the fact that he didn't back up and he continued the encounter shows, frankly, psychotic behavior.
All right, but that's a question of fact for the jury. I find that the elements of the crimes as charged, felonious assault and felony firearm were committed. There's no reason for me to make any findings on count 3. I'm going to bind the defendant over for further proceedings. The AOI date he's posted is found at 20,000, 10% will be at 9 a.m. on July the 14th. Counsel, Mrs. Morrow, do you have any objection to the continuation of the bond?
Your Honor, I was going to ask you to have the cellar removed based on the heard. I think there's at least a serious question of fact as to who's the actual aggressor.
But I would judge to remove.
I keep the tether on. Bond conditions are continued. Nice to have you here. July 14th. Thank you very much.
Thank you, Judge.
Are we done for the morning?
You're browsing out, still has one.
Do a vessel? Oh, is it not my?
Well, I've got to get out. I need to get out of it a little bit.
You can call see resentment.
Because if not, you can go do a lunch. Take care, Mr. McGowan.
Yeah, you ready?
Your Honor, do you have, can I talk to you in chambers about something completely unrelated to this case?
Nothing to do with this case?
Nothing whatsoever to do with this case.
Go to lunch.
Sure,
Do you have a moment?
sure. You,
I'll put you up in hold.
you know I would never talk to you about case, right? Okay,
Graziano given consent.
okay. Come on in real quick.
See you guys at one.
Just follow her. Right to the right there. Yep.